Well, the petitioner is challenging the order dated.
Make use of the mic.
The petitioner is challenging the order dated 12/11/2025 in WPC number 25066/2024. The main ground is that, my lord,
Please repeat the first sentence. We did not.
the petitioner is challenging the order dated 12/11/2025 in WPC number 25066/2024 passed by the Honorable Single Judge of this Honorable Court, my lord. The petitioner is Sarpanch, my lord, Cheleguda Gram Panchayat in the district of Gajapur. The opposite party number present, respondent number 2 filed the election petition before the law court below, man. This please that.
You are return candidate.
Yes, ma'am. Please that, my lord, the petitioner has 4 children after amendment of OGP Act 1994.
Covered by judgment. Which is that judgment? Therefore, your election petition is allowed and you are sent home.
No, my lord.
No.
My election petition passed the order. Election petition filed by respondent number 2, my lord. And wherein, my lord, I am disqualified.
Challenging disqualification. This was allowed by the EP, between the EP,
yes.
All right, before the tribunal.
No.
Then you preferred appeal before the district judge.
Man.
It was confirmed.
Confirmed.
Then you came to first the
Honorable Court.
dismissed. Again dismissed.
My sole grievance is that, my lord. As per allegation, as per allegation of respondent number 2, I have 4 children. But I have really 2 children. Another 2 children, my lord, is children of my cousin brother. When the wife of my cousin brother Benu,
Brother, how we should examine question of fact? EP decided by a judge. District judge rejected your appeal. Learned single judge said 2 orders are right. And how we can interfere in that? This is a 227 petition. It's a fact. It's a finding of fact.
Yes.
How can we interfere?
my lord, my sole grievance is that when I have 2 children.
That's what you told it to all the 3 judges.
And yes, but at the time of election appeal, my lord, unfortunately, by the wrong advice of my conduct counsel, this statement is
Wrong advice is given, and if somebody marries on that ground, can you divorce? No, I had wrong advice from my lawyer as to the marriage, and therefore I married. Advice is wrong. Set aside our marriage. Divorce. Can it happen? Same thing will happen.
Your lordship, my kindly issue.
No, nothing.
They have filed the counter appeal.
No, nothing like that. 3 judges have held against you. How we can interfere with that? It's a writ appeal under 227. It arose 226, 227, not 226, because you are challenging order of the district judge.
Yes, my lord.
Therefore, it is 227. In 227, what is scope of our power?
Maybe Honorable Court may give opportunity to the appellant.
This intra-court appeal seeks to lay challenge to a learned single judge's order dated 12/11/2025, whereby appellant's WPC number 28836 of
25066. Another rate filed by
25066 of 2024 has been negative. First, in the said petition, apparently filed under Article 227 of the Constitution of India, notwithstanding ornamental invocation of Article 26, challenge was to the order of the district judge who had upheld order of the civil judge, junior division, or junior division, by which the EP number so and so filed by the respondent number 2 herein having been favored, comma, appellant's election came to be voided on the ground that he has more than 2 children as on the cutoff date. First stop. Next paragraph. Learned counsel for the appellant vehemently argues that his client has only 2 children, and therefore the finding as to he having 4 is unsustainable, and as a consequence, all the 3 orders of the courts below have to be settled. First up, who appears for the other side?
My lord, I am.
Learned the AGA madam on request appears for OP number 1. Learned counsel Shri so and so volunteers to appear for OP number 2. First, they resist the appeal, making submission in justification of the impugned orders and the regions on which all they have been constructed. First, they tell us that the challenge before the learned single judge was under Article 227 of the Constitution, and therefore the writ appeal itself is not maintainable in view of full bench decision dated so and so. First, they also further say that an intra-court appeal of the kind, by its very nature, has conventional limitations, and therefore it cannot undertake a deeper examination of findings of the fact. First, next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court declines indulgence in the matter, broadly agreeing with the reasoning of all the 3 orders and also the submission made on behalf of the respondents herein. First off, by and large, the subject matter of this petition, this appeal, is similar to the view taken by a full bench of this court in Navanita Kapata Patra versus Collector Kandamal. Report to 3-judge bench. No, 3-judge benches was no. That's one. Which is the citation? Just give them. Next paragraph. The above apart, in view of decision of the apex court in Sridhar Mirajkar versus State of Maharashtra, they are 1960, 65, 66, Supreme Court page 1, comma, just look into that. An intra-court appeal of the kind does not lie when order is passed by the learned single judge under Article 227 of the Constitution of India. First up, even this view is echoed by a full bench decision of this court in Soil. So, madam, that you had other day, you had given that.
Yes, Your Lordship, I.
In the above circumstances, appeal being unworthy of consideration is liable to be and accordingly rejected in limine. Rejected. Of course, having been making. Next.
Item 3, WPC 35559 of 2025.
Right. Yes.
My lord, this case pertains to
May please, Your Lordship, item number 3, the name of the counsel for the petition may be deleted as the pre-petition counsel.
Which concept to be deleted?
Sagar Mishra.
Please
Sagar-
make use of the mic.
Please use.
Your Lordship, Sagarika Sao, A. Mohanty and D. Patnaik.
Sagarika Sao to be removed.
Yes.
I have filed my Baklatana.
You appear for in the stead of
Yes.
Sagarika.
Yeah.
Right?
Yes.
Srimati Sagarika Sahu, learned counsel appearing for the petitioner, is permitted to retire from the case. And in her state, Mr. Patnaik appears is permitted to appear. But anything to be said? Only this.
This much, my lord. My lord, my lord, here is a case, my lord, where the assistant engineers of works department, my lord, the post were, my lord, like around more than 600 posts, my lord. Now, what has happened, my lord? There was an advertisement in 2014 and 2 corrigendum were issued, my lord.
My brother is saying
My lord,
that his brother has decided the matter.
my
So
lord,
let it go unnecessarily why to give scope for allegation, etc.
my lord.
Post this matter before a bench which does not comprise of brother judge. Next.
Item 4, WPC 2626 of 2026.
Yeah.
That annexure 5, that is the order passed by the Honorable Tribunal in OA number 470 of 2020.
Yes, brother.
In OA number 470,
Can it come before Monday, my lord? It is.
No, it is to be just by the
Chief
day.
Justice.
My-
Goes before the Chief Justice. Yes, brother.
by challenging the order dated 9/5/2025, passed by the London CIT Court of Bench Court in OA number 470 of 2022, the petitioner is before my lord. This matter relates to a departmental proceeding, my lord, where a punishment
They are
imposed,
challenging a tribunal's order.
my lord. And
Departmental
annexure
proceeding
5 page starts from page 440, my lord.
for 40.
My lord.
What was the allegation against?
Allegation was unauthorized absent, my lord.
Absence.
My lord.
Unauthorized absence.
Yes.
Unauthorized absence for how many days?
How many days?
From a 3.5 months, my lord,
3.5 months.
only. And that period is important, my lord. Period from start
That
from
is the
eight.
only single count or a habitual absence.
This is the only single one.
Only.
And the period is important, my lord. Period is from 8/4/2020 to till the date of issuance of charge memorandum, my lord.
8/4/20.
2020, my lord. And when there was a lockdown and shutdown, this was taken by state government as government of India, my lord.
8/4/2022.
To, my lord, till the date of issuance of memorandum, my lord.
Date
7/8/2020, my lord.
7/8/20.
My lord.
What is your designation?
I am a
Senior commercial clerk.
clerk.
Senior commercial clerk.
Clerk.
Yes. He has himself absconded from the office without informing any
How
of.
many years of service he has put?
Since 2004, my lord.
Why were you away?
My lord.
How well? Well, when you were appointed? Turning the pages. Even your petition book is a.
Yes, my lord. I mentioned in my grounds, my lord.
Well, right. Why did not you bring your check?
I have already marked the step.
Go on turning the pages till the cows come back.
Page 18, my lord.
I don't need a page. We asked you date.
7/1/2004.
That. 7/1/2004.
4.
Any promotion you have earned?
So from junior clerk to senior clerk, during my course service.
One promotion.
My lord.
When your promotion?
That date I have.
What is this, brother? Very relevant factors not relating to disciplinary inquiry. You should just look into all those things. Otherwise, that one argument like this will not help. Why were you absent?
But because I was ill. I was discharged from Divisional Railway Hospital, Hon'Ble.
When were you admitted?
My lord.
When were you admitted?
That fact is part of charge memorandum, my lord.
But you don't know. When were you admitted? You don't know.
When he was admitted, why he was admitted, which hospital he was admitted to.
Then the
When
Lord
he
may
got discharged.
pardon this matter next week. I will
No,
prepare-
we'll not do that. We are dismissing the petition.
Sorry.
We are dismissing the petition. Otherwise, all this indiscipline, already there is indiscipline, non-performance. We have patience. All substandard advocacy.
Then after launch, man. Today after lunch, I'll give the only the dates.
No, sir. We want to have one free bite. For every mad dog will have one free bite. Like that we'll do now. Because 100 times we have said, at times I have antagonized the members of the bar. I don't care. I'm not going to contest election. Nobody comes with preparation. If you come with preparation, we are here to grant relief. And you do not do. Coming here and turning the pages, putting your finger on the tongue and turning the page. Who wants all those things? All ugly things we don't want here. This is a sacred place. Court is a sacred place. When was he admitted to hospital? When he was released, discharged from the hospital. What is the discharge summary is saying? This is the only point. Turning the pages endlessly.
It was only one person.
Second-rate advocacy. Yes.
Item 5.
When you are sitting in the court hall, why can't you make notes? Just turning, chit-chatting, disturbing all persons who are arguing. What is this going on? All circles is substandard advocacy. Yes.
Item 5.
Yes, sir.
WPC 8561 of 2026.
My limited prayer is my grievance pending before the OP number 1, OP is kindly dispose of the direction.
OP number?
OP, only OPs, ombudsman.
Matter is pending there.
Pending
19/12/25.
20.
If a direction is issued to consider, that is sufficient.
So,
Annexure 4.
Annexure 4. Who appears for your opponent? Who is your friend?
no ombudsman.
Then we will direct them because we will say pass order if it is pending.
Yes.
Short grievance of the petitioner, power consumer, registered power consumer is as to long pendency of his grievance petition pending on the file of the Ombudsman 1,
Redco Colony, Bhubaneswar.
who is respondent number,
What?
so
Only one.
who is sole respondent here. First off, learned counsel for the petitioner submits, and we agree that grievance of the kind cannot be kept lingering, and that the same needs to be treated on a war footing, the electricity being the lifeline of the people as held by the apex court. Take out that judgment. So and so. First off, we have consciously chosen not to issue notice to the other side in as much as the prayer is for passing, for a direction, for an order to pass order on the grievance petition, keeping open all contentions of the parties, especially when right to speedy justice is found to be is treated as a fundamental right. First off, next paragraph. In the above circumstances, this petition is disposed of, directing the OP to hear and dispose of the grievance, which is that number. Which is the number of the grievance petition?
Only Annexure 4, madam. Annexure 4.
As has been reflected in the document at Annexure 4.
Dated 19/12.
Dated 19/12/25. Within 8 weeks. Of course, after giving an opportunity of hearing to all stakeholders. First of all contentions are kept open. First of all, registry to send a copy of this order to the OP by speed post before sunset of the day. Write that order and bring it here for signature. Yes.
Item 6. WPC 8791 of 2026.
May I please, Your Honor? This petition is against the order of the Learned Central Administrative Tribunal.
Yes.
Before the Learned Central Administrative Tribunal, 2 prayers I have made. First prayer, that refixation made after my retirement and reducing my pension
On that basis.
on that basis is illegal. Secondly, recovery effected on the basis of that refixation, that is also bad in law.
What is your, is it Masi? Rashfik Masi is applicable, no?
Then Lorna Tribunal has accepted second part. So far as first part is concerned, refixation, that Lorna Tribunal has committed the basic mistake while considering their statement, review statement. The Lorna Tribunal failed to take note of Rule 7 of the CCS revised pay rules of 2017. My lord.
That was not argued before the trial?
Yes, my lord, that was argued. Not only that, by filing the review, I have explained also that this is the place where the mistake has been committed.
Review is also rejected.
Rejected, my lord. There I have.
You take Mr. Padi. First party is concerned, Rafiq Masi.
My lord.
That the court, the tribunal has followed. The second party says his entitlement itself is put in challenge, ignoring this rule. You take notice. You take notice. There is an issue. Heard as Floodlight Council appearing to the petitioner, employee, pensioner. First off, the case is made out for issuance of emergent notice. First off, issue emergent. Any interim order you sought for? No. Issue emergent notice. Mr. Padil and the DSG on request accepts notice for the press. Office.
All the office.
All of this. Next.
Item 7, WBC 9981 of 2026.
And I'm we
Yes, sir.
not a time to answer, but
I tell which.
item 18, my lord,
18.
2 p.m.
Today is 2 p.m.
But Leonard requested a special bench question in Supreme Court. But tomorrow at 2 p.m. I went to the other side.
No problem. No, but inform the other side.
Already informed.
Yeah,
If the court
we'll have
has
it
not
next
informed-
week. We'll have it next week. Any urgency?
No, there is no urgency.
No
But
urgency.
the Lordship will fix specifically at 2 p.m. That's why.
We have that Mr. Venkatraman ESG had appeared, na?
Yeah, yes.
We'll have it next.
He requested
Tomorrow we'll have it.
tomorrow 2 p.m.
Okay, 2 p.m. Yes.
May I praise your lordship?
Sorry, my lord.
But inform Mr. Mohanty.
Yes, yes, already informed. It
Informed.
would be, if the court permit, I don't have.
Okay. Do you have Mohanty's number?
Yes, yes, already I spoke to him.
You speak to Mohanty, sir, and tell him.
I have
you
the
posted it. on-
Just now I was in the.
Okay. Yes.
Item 7,
May I praise you? My lord, the petitioner may introduce the MSME unit, my lord. It's availed a loan in the month of March 2018, on 23 March 2018.
23/3/2018.
18, my lord. Here,
How
my lord,
much loan?
term loan was 22 lakhs and cash credit limit was 5 lakhs. My lord, say unit was moved all production unit, my lord. Due to COVID, has made financial hardship, could not run, materials were not there. The collector accordingly under Annexure 2 requested the bank that since it has been closed down, so you take steps for financial assistance to revive the unit. Well, while the matter that stood as that, my lord, so subsequently the petitioner defaulted in payment of the loan, my lord. But,
From 23/3/2018
my lord,
till COVID was
COVID 2020.
COVID was declared on 25/3/2020.
2020.
How much money you have paid bank?
My lord, there I paid, my lord, that my lord, on 2023, my lord, a demand notice was issued, wherein the liability was fixed as 25 lakhs, my lord.
We're asking a question.
My lord,
How much money you have repaid
my lord, that till 2020,
till 25/3/2020? That is the notification,
Well.
COVID notification.
well, that, my lord, statement,
Not available.
they're not available.
All right. How much money? All right. Till date, how much money you have paid back?
My lord, we have paid, my lord, around 5 lakhs odd, my lord.
Only 5 lakhs.
My lord.
The interest component will be 5
My
lakhs.
lord, my lord, now what has happened, my lord? They issued an auction notice, my lord,
On
13/11/2025, my lord.
This is section 13 notice.
My lord, section, rule 86 of section 13(8), my lord.
4.
Security enforcement rules, my lord, 2002.
Section 13(4).
My lord, my lord. The sale notice, e-auction sale notice.
That is 18(8) of the security interest rules.
13(8) of the security interest rules. This is auction notice.
My lord, e-auction sale notice.
Huh.
My lord, page 24, my lord, here they say it's for recovery of 19,30,296
19,30,000.
as on 8/11/2025,
Huh.
including interest and other expenses.
Okay.
So pursuant to this notice was issued on 13 November 2025. My lord, thereafter the petitioner approached the bank, my lord, for OTS. After 2 letters, my lord, in the year February 2026, they intimated the petitioner that the sale has been conducted. I have annexed that sale confirmation letter which has been communicated to the petitioner through mail on 24/2/2026.
Sale was conducted on
Sale, my lord, they say on the same day, 24/2/2026.
Huh.
They say the highest bidder has offered 12,18,000
Huh.
and 25% of the bid amount was deposited by the bidder, that is 3,04,500
On the auction day.
of the
Huh.
Madam, the bidders was supposed to deposit the balance amount of 9,13,500 within 15 days.
Huh.
That is by 11/3/2026.
Huh.
That to my knowledge, I have also stated in the writ application, this sale
Not
has
paid.
not been confirmed. In the note.
We'll ask him. Okay. Is it true?
My lord, I have instructions to appear. Let him serve a copy of it because it seems what I was seeing that matter is pending before the DRT1 OA has been filed.
Bank has filed, I have annexed that summons also, and we have appeared.
Which is for recovery.
Yes, by the bank.
By the
This is
bank.
of course a separate
It's a
proceeding.
separate procedure.
Well,
No, whether that 75% amount is just, I'll go and ask by phone over your.
Let him give me a copy.
Give copy.
well,
Which branch I can find out.
Correct. Yes, just we'll call it after you bring that information, we'll just mention to us, we'll call that matter. If sale is not yet confirmed, then you have to
There
give
is a
some brief.
provision. It can be extended for at the outermost limit for 3 months time.
Thereafter, money is forfeited.
Yes, my lord. Thereafter, even thereafter, even if he gives money, that cannot be accepted.
That cannot be.
There is a
Therefore-
two Supreme Court judgments on this.
There, of course, Justice Chandrachud's judgment, Honorable Justice
My lord,
Chandrachud.
my lord.
Yes.
Yeah.
Just go and bring that information. After you get that info, just mention here.
My lord.
Item 8, WBC 10090/2026.
It's just the petitioner is the borrower to a housing loan.
Go borrower.
Borrower to the housing loan. The original loan is the son. And the loan amount
Original loan, original loan?
is the son of the petitioner.
Son, father, son relation.
Mother son, my lord.
Mother, son.
The joint property, the ancestral property. And the loan was granted for housing loan purpose only 4,64,618.
Which you mentioned yesterday.
Yes, my lord.
Huh.
That only in the year 2018 repayable in 180 months, that is 15 years. The amount was paid from the pension, the petitioner is a family pension holder from the pension, but subsequently they felt the difficulties, and the son is also a government servant working under the West Bengal government. He is not taking care of the mother and he is residing in Delhi. The loan account declared NPA 2025, May 2025. And the outstanding dues as per the sanction 32 notice matter under Annex 3 is 5,16,619. The lady wants to regularize the loan account by paying the overdue amount, and so that the repayable period is till 2033, man.
33.
Man,
That outstanding is how much?
5,60,619.
Total amount. The 5,16,619.
No, what is amount payable?
That is full amount payable, but the overdue amount they have not break up.
They have not, generally, how much it must be?
Around 1 lakh sum.
You pay 1 lakh rupees.
Well, I am ready also present. For that purpose, I have the physical possession has been taken on 2nd December. They have proceeded for auction sale notice under Annex 1 that was failed as per the
Should. Challenges to the coercive recovery proceedings by the scheduled auction provided under the provisions of the Success Act 2000. First, petitioner happens to be a senior citizen lady, and a pensioner. First time. Whether son you have made respondent?
I have responded number 2.
She happens to be one of the borrowers along with the son, who happens to be OP number
2.
OP number 2. First up, this OP number 2, counsel for the petitioner submits, is employed in West Bengal government, and that he is abandoning the mother who is in financial distress. First up, he also tells us that the petitioner, poor lady, is ready and willing to credit to the loan account a sum of rupees 1 lakh if easy installments are granted, and further to clear the loan within a reasonable period. First up, therefore, he presses the application in IA number so and so, supposed by an affidavit. Next paragraph. Having heard the counsel for the petitioner and having perused the petition papers, and also having seen the old petitioner lady personally present before the court, we are of a considered opinion that reprieve needs to be granted to her in the following form, and accordingly it is. First, the petitioner shall deposit credit to the subject loan account a sum of rupees 1 lakh in 5 equalized installments, first of which will commence from today. First of each installment will have the grace period of 2 weeks. 2 weeks. First of, if the interim relief, the condition subject to which interim relief is accorded or not complied with, petition may be dismissed. Print that order. Yes. Yes, come now. Yeah. You should not mistake when judges say, when judges point out your mistake, you should accept it and be gracefully accepting it. We also accept our mistake if it happens. Okay.
Item 4, WBC 2626.
My lord, he made an accident on 1st January 2020, my lord.
It was a case of accident. See, such a good ground you have got, and you are not telling.
His name was remained in the sick list from 3rd January, my lord.
1 second. When the accident took place?
1st January 2020, my lord.
You said you were absent from which date?
My lord.
You were absent from
18th March 2020.
2020, you remained absent.
No.
On 8/4/2020, I remain absent till the date of issuance of charge memorandum, my lord. That is 7/8/2020.
8/4/2
7/8, my lord.
7/8/2020.
My lord.
All right. You were admitted to hospital when?
My lord, on 18th March 2020, my lord.
You were hospitalized.
3.
I was admitted as an indoor patient in the divisional railway medical at Sambalpur, my lord. I remained there till 14th March, my lord.
18 to 14.
On 24th March. 24th March.
15 days.
My lord.
Then you became all right.
Then, my lord, I discharged by the divisional railway medical, my lord.
On 24th, 3 discharge.
My lord. To report
March.
March,
So
my
you were there for only 6 days.
6 days, my lord. 18 to 24.
6 days.
My lord.
What was the nature of accidental injury?
My lord, I sustained fracture, my lord.
What is that fracture?
That
Fracture
is
has
not,
been-
no medical report is there, only discharge certificate is there and pleadings are there, my lord. While he discharged me by the divisional medical, they advised me to report before the additional district medical officer Titlagout, my lord, for my further treatment. That I could not avail, my lord. So from that period, it was unauthorized absence, my lord.
But you could have informed the employer. See, I have suffered vehicular
Because of I belong to non-Odia, my lord.
No, that is it.
And because of that, no communication facilities. It was
Why in
not
English,
possible.
Hindi? So how many languages are there in the 8th schedule?
You are working with the
constitution.
railway or no?
In the earlier, my lord.
How you are communicating? By signs. Only signs and gesture. Then you must be speaking
My-
something. You must have given your journey report. No, never.
My lord, I could not able to report in the medical.
That is what. If you did not report in the medical, you
Well-
could have asked it, communicated to your employer.
That is my fault. I am considering before, my lord. I could not able to report.
So what happened from 24th of March to 8th of
April.
April? Sorry.
7th,
No, 7th of April. What?
7th of August, my lord. 7/8/2020.
No.
No, 8/4.
8/4 you first tell. From
Well-
24 to 8/4. Where were you? You did not report in the medical.
No.
So where else?
I was at Kontamanji, my lord. I saw it in my place,
So you remained in your house
my lord.
without informing anybody.
My lord.
Then you remain there only.
Yes, my lord.
Then go home.
No, I have not gone home. I remain in my quarter, my lord. A charge sheet issued,
No.
alleging that I could not able to report before the additional divisional medical officer at Titlagout. So they issued a charge sheet, my lord, saying that my period from 8/4 to till date of issuance as honor.
7/8. 7/8.
7/8, my lord.
Yes. Mr. Padi,
So
there is a person who has put in some long service, and in appreciation of his service, you have promoted him also. Okay. He met with an accident. That is not in dispute, perhaps, because he was admitted to hospital. He was undergoing treatment. That was during period 18/3/2020 to 24/2020. For 5-6 days, he was in the hospital. There is one judgment of Apex Court under Motor Vehicles Act, where a person is hospitalized for break of the bone for 5 days or more. The presumption is he requires 30-day rest post-discharge. I don't remember that judgment. There is one such judgment. So his mistake is in not informing them.
No, but he is absent from April to October.
Correct. 8/4 to 2020
Yes.
to 7/8/2020, not October.
3.5.
Correct.
Yes.
What? Whether railways come to a halt? He is not managing director of the railway
Well,
company.
it's true,
He
but
is a clerk.
senior council manager is also very important. It is not an issue. Issue is that a person responsibility holder of the railway.
But dismissal
Appears to be too harsh.
Plus,
You take notice. You take notice. The case. See, he has earned one promotion. That means his work was appreciable. Maybe one fine day he met with the accident and there's
so that's why the query was.
some other punishment you can give.
Measures for the penalty of dismissal is.
This measure is too harsh.
his period you might not have
You
treated
cannot
as-
be that harsh.
I'll-
Because he is a lower rank official. It is not that all trains came to a halt because he was absent.
It's true.
Huh? Therefore, just look into heard learned counsel say so and so. First off, the case is made out for issuance of emergent notice. First off, issue emergent notice. First, Mr. Padi, learned DST is requested to accept notice for all OPs. All OPs. First off, matter lies in a narrow compass, and therefore posted in the on the reopening day after the summer vacation. Okay.
Obliged.
Kindly do not mistake.
I'm sorry.
Yes.
Item 9, Rate Appeal 830 of 2024.
I'm thinking how to make mention, my lord.
We have understood what the case is now. Yes.
Here, learned single judge is directed for 18% interest and subsequently modified to 7% interest.
That also you don't want to pay. You don't have interest to pay the interest.
That is,
Or interest to pay the principal also.
that is, my lord.
There is one famous statement which I quoted in one of the judgments in income tax matter. The money was payable for having stitched a particular coat in Ireland.
Yes.
Irish actor, he was very humorous person. I forgot his name. Could you get it from Wipro Industries versus Chief Commissioner of Income Tax? So he said that the tailor asked that you have not paid the principal amount, nor you have paid the interest on the amount. But that dramatist said, my principle is that no interest shall be paid. And my interest will not be served by paying the interest either. That's exactly what you take. There is a delayed payment.
My lord, it is a matter relating to payment of pension, in fact. Pension.
The Padmanabhan Nair,
Yes.
85 Supreme Court.
Yes, yes. Their lordship have also cited a judgment.
That Chandrasekhar Gambara versus Bangalore University.
Their lordship have also cited another judgment.
Padmanabhan Nair versus
Yes, Padmanabhan
85 Supreme Court.
Did it Tiwari versus Uttar Haryana Bijli.
Correct.
Their
That's
lordship
where they
cited-
refer to that Padmanabhan Nair itself.
They have referred to in that case.
There is nothing.
My lord, so
7%.
7%. It was modified subsequently.
18 to 7% it has been.
7%.
Yes, 7%. We will increase it to 9 now.
My lord, I am praying that let it be 6 at least. Minimum.
That was under section 30 of the CPC.
CPC.
That here it cannot.
Let it be 6.
30, section 30 was coined in 1862 CPC.
My lord.
Then in 1948 CPC it continued. Unfortunately, even after 76 extensive amendment, it continued. I don't know why it continued that way. When the whole world is moving towards higher rate of interest now, at least in India, Asian subcontinent. In other countries, you only have to pay interest for keeping the money with the
Simply
bank.
interest may be imposed. My lord.
Take down. The state and its officials, what do they call state? State and its officials are invoking the intra-court appellate.
Let that be 7, my lord.
Huh?
Let that be 7.
7.
Will not pursue further.
Take down. The state and its officials are invoking the appellate jurisdiction of this court for laying a challenge to the orders dated 10/11/22 and 11/12/2023 made by the learned single judge judge, whereby the WPC number 29806 of 2022 filed by the sole respondent herein, having been favored, interest at the rate of 18% was awarded, and that came to be scaled down to 7 on the delayed payment of pension. First, kindly be seated, Mr. Chief. We appreciate your advocacy skills. Next paragraph. Having heard learned AGA appearing for the appellants and having perused the appeal papers, we decline indulgence in the matter in as much as pension is not a bounty but a justicial right, said the apex court in Shivanandan, no, which is that? Mishra. D.K. Nakar, D.S. Nakar versus Union of India. Devaki Nandana Mishra. Devaki Nandan Mishra versus State of Bihar. Correct, it's not that. So and so. And reiterated in D.S. Nakara versus Union of India. First time. They said a profound statement was made by the apex court after seeing the culpable conduct of state and its entities in delaying or denying pension to an employee who demits office after shedding his sweat, if not blood, in the service, in the public service. First time. Further, it is also held by the apex court that amount payable to a pensioner constitutes a property under Article 300 capital A of the Constitution of India, and withholding it amounts to temporary requisition, which cannot be done without done on the justice cannot be done except in accordance with law. First time. Next point. Whenever terminal benefits are settled belatedly, the pensioner is entitled to interest on the delayed payment. Said it as observed in Padmanabhan Nair versus State of Kerala.
State of Kerala.
State of Kerala, 85 AR 85 SC, so and so. First off, the impugned order of the learned single judge accords with this long-standing jurisprudence. First off, even under the provisions of Interest Act 1970, just looking. Interest Act so and so, delayed payment attracts interest in varying rates. First off, learned single judge has chosen to levy 18% earlier, and that has been scaled down to 7 rightly. First off. Next paragraph. In the above circumstances, appeal being unworthy of merits is liable to be rejected, and accordingly it is, in limine. First off, the order of the learned single judge shall be given effect to immediately, failing which the interest rate at 7 would stand enhanced to 18. Okay. The interest component may be recovered from the hearing officials of the state. Yes. Register to send a copy of this order to the respondent employee immediately by speed post. Okay.
Item 10, date appeal
There is a limitation in this matter, delay of 100 days.
100 days.
100 days.
Covered matter, rehabilitation appointment.
Covered by judgment.
No.
But
Sorry.
Earlier, one more ground you have to put. The above apart, the appeal is filed after booking a day a delay of 100 days, and an application supported by the affidavit so and so is moved, seeking its condonation. First up, we need not undertake a deeper examination of this aspect of the matter, since on merits itself, the appeal is unworthy of consideration. Okay. Next, the structure that segment that way. Just look into that. Okay.
Item 10, date appeal 2784.
Item 10 is a state intra-court appeal. Of course, in the meantime, that rehabilitation assistance scheme upon amendment of 6(9),
Covered by
Jita Luha, that has been covered below.
Prior to commencement the rules. New amendment.
The state and its officials are calling in this intra-court appeal, the state and its officials are calling in question a learned single judge's
1511.
15/11/2022, whereby respondent employees WPC 29927 of 2022 having been favored, the following relief has been accorded. Just look into this paragraph. Okay. Paragraph 7. Full 7. Full 7 you just got some time. Okay. One second. Full entire proceedings. Next part. Learned counsel appearing for the respondent employee. How many? Only one employee. What about another employee's appeal? One employee tells us the subject matter of this appeal is substantially similar to the one in writ appeal number 2099 of 2024 between State of Orissa and another versus Viraja Chaudhary and another, disposed of by this very bench, wide order dated 9/3/2026, dismissing the same. First up. Next paragraph. Despite some submission, learned AGA is not in a position to differentiate the fact matrix of the cognate decision from that of the appeal at
And
hand.
that is squarely covered, my lord, because after
Covered.
Jitalwa, because it is a matter of 2023. By that time, Molan said,
No, he said this to save you because you are not. They should not say you are not argued anything yet. Next paragraph.
Para 3, it has been quoted, my lord.
Yes. In the
New rule
next
came
paragraph.
in, new rule came into force on 4/4/2025.
In paragraph number 3 and 4,
Yes.
3, 4, and 5
5.
of the cognate judgment, the following observations appear. First, next paragraph. In the above circumstances, this appeal is also disposed of in terms of the cognate judgment referred to above, mutatis. No first.
Hello, similar delay is there, that may be
No, that is already.
Delay is already condoned.
condoned.
278.
Yes.
This is IA. was it?
IA.
For 7 to 8 times. Notice was issued. Since 59 days.
Brother, 1 second. We'll condone that delay.
Yes.
659 days.
659.
Then we will not condone that delay. Next one more point. The above apart, the appeal has been filed after looking a long delay of 659 days with no plausible explanation, as we found out from the application in IA number so and so 7285 of 2024, supported by affidavit. First of all, the sages of law say that law and courts will not come to the aid of sleepy and tardy. First of all, that applies to this appeal. Okay. Next.
Item 11, WPC 5186 of 2026.
May please. Like
Yeah.
in this case, my lord, the earlier order dated 23 to 2026, my lord, specifically directed to the petition to clearing all the installments till date within an outer limit of within 3 weeks. And after obtaining the certified copy of this honorable court, the petitioner approached the bank authority, that is OP number 4, to clear the outstanding amount, that is 2,60,000.
Yes.
That is 2 lakh.
Start now, afresh.
Yes, my lord. May I please?
Order dated 23/26.
26, my lord.
Ah.
My lord specifically directed the petitioner to clearing all the installments till date within an outer limit of within 3 weeks. After obtaining the certified copy of this report, the petitioner immediately approached the bank authority, express readiness to pay the outstanding amount, that is 2,67,064 only. That is annexure 1 of my IA. But the bank authority refused to accept it. On the other hand,
Why they did not accept?
he stated that unless the entire outstanding liabilities of all accounts, that is 23 lakhs 30,965.83 is paid.
Huh.
I was specifically directed to the petitioner to deposit all the installments.
All the installments.
My lord, deferred installments. That is 2,67,064 only. That is annexure 1 my IA, my lord. Specifically, they have also issued a notice on dated 10/10/2026.
You appear for bank.
My lord, I am.
What has happened in this?
My lord, in this matter, is very intelligently he has filed this writ petition.
He is intelligent only, like you.
My lord, he the petitioner is the mortgager, guarantor and mortgager. The principal borrower is the Subramshu Sahu, who is the son of the petitioner. And his husband is also one of the guarantor. What happened, my lord, in this loan amount availed by the Subramshu Sahu, because he is a principal borrower, other than the guarantors, in the customer ID, he has availed another loan that is also NPA, the cash credit loan. That account was NPA, and he has taken another loan, that is personal loan, another is a credit card loan. So taking into the customer ID, classification of the NPA is always a borrower wise, not account wise. So this being the position, the NPA will be lifted and when all the other accounts to be cleared. Otherwise, NPA will not be lifted. Once a NPA will be continued, certainly surpassing proceeding will be initiated. In this matter, my lord has passed an order on 23rd February. Thereafter, 21 days, after 21 days, even he has not paid that amount, and bank has also requested him to pay the dues because
How much it will be?
around 23 lakhs.
No, that is installments. How many?
Milord, so far this is the housing loan, Milord. This is a housing loan. Now, as per the installment was taken of rupees 8,000.
How much he has to pay as per the installment?
8,932, near about 6 lakhs, Milord. He has to pay because 2005
All the
years.
3 loans.
Milord, one loan. I am saying the only housing loan, but he is having another business loan. That business is also closed to that account. This is the position, Milord. That is the only, we want the money. Let them pay that amount, the house.
My lord, can I have glance me? Annexure 1 in my IA, my lord. They have issued a letter.
Now-
Specifically, they have stated
It is a loan.
loan, housing loan, specifically.
Please listen. It is a loan. And you have taken 2 more loans. Okay?
My lord.
Rightly or wrongly. Now, since it is a housing loan, we were showing some mercy.
My lord.
Now, they have said what is the amount payable by you. Do you want to pay or not?
I am ready to pay.
How much you?
Ready to pay. Now I am ready to pay 2 lakhs.
Not 2 lakhs. 5 lakh. How much it is?
My lord,
With permission.
Huh.
If he has not paid that amount as per the lordship's direction, then bank on 17th March, bank notified another auction notice, and on 4th April, the property was auctioned to the tune of rupees 24,54,300. So now
Even when the court order was there.
Yes, ma'am. Yes,
within
ma'am.
time stipulated, I'm submitting you. Within time stipulated, the directed amount has not been paid. Suppose now he's taking the allegation against the bank that money has not been accepted. If the money is not accepted, you have to come with a demand draft. When the my lord has passed a specific order, certainly then bank has requested to pay this order as per the direction of the interim order.
Even
This
that
is-
he has not paid.
2020.
My lord, on 3/3/2006, bank has requested at least the interim directions order में पैसा थोड़ा दे दो.
That he has not.
That has not paid. If he would have paid, matter would have not been gone to that stage. This is the position, my lord. He has invited and very intelligently, my lord, another point, he has made a part to the government of India, the Secretary Finance, Union of Bank of India. Normally I am a standing counsel, I will come up. So avoiding me, I will come up and raise these issues. He has stated that government, Union of India represented by Secretary Government of India.
No, you should thank him. He would have made United Nations as a party.
This is the position you also kindly see.
My lord.
You have not impeded which bank you have impeded. Read your cost sheet.
Yes, madam.
Reserve Bank of India and everybody is.
Union of India.
Union of India.
Your union.
Because you, bank,
No, you have made a party.
yes,
3 and 4.
3 and 4. Regional manager, Union Bank of India, A by 1A, Civic Center,
3 and 4
ISB.
are part.
Yes, four.
One is the Secretary, Union of
One is
India.
secretary. Reserve.
Oh, you are concerned.
My lord, this is the position, my lord. We want money, my lord. Lordship, kindly visualize this situation.
Now, what happened to the auction?
Auction was successfully held for rupees 24,54,300 and 25% amount has been paid because sale has not been confirmed unless 100% amount to be paid. So 75 balance 75% to be paid on the 19th April 2024. So this is the position. Now, if he will pay this amount as per the Lordship's direction, what are the and besides this, the others loan
You have not
account.
completed the sentence. If he makes the payment,
My lord,
sentence complete.
my lord.
Complete the sentence.
If this installment so far the housing loan is concerned, when he has approached to my lord, and
If he pays,
and simultaneously he has to clear the other NPA account because the NPA will not be lifted unless that account will be closed.
but the question is,
My lord,
house, there is an order.
my lord,
When there is an order,
my lord.
you should not have gone for auction at all. You should have come before the court. Sir, he has not complied with the order. Therefore, you permit us to go for a public auction.
My lord has a categorical stated failure to deposit. So the dismissal of the representation line.
Now, if he pays that money, which is that 5 lakh odd,
My lord.
you do not confirm the
Yes, that is one part. And
remaining we look into. First, show your bona fide.
and others, the other
Others
account
we look into.
to
Now,
definitely
let him pay
because-
5 lakh, which is that 5 lakhs?
6 lakh something.
6 lakh something.
My lord,
How much it is?
5 lakhs,
No.
5 lakh plus?
43,000, 20 below.
You pay 5 lakh 50,000 and then argue.
My lord, one thing I pray, my lord. One thing I pray.
You have the other loan also. Otherwise, we will make 30% of entire other loan.
Other loan is CC loan, my lord.
That also will make you have all three.
One thing I pray, my lord. Outstanding SME loan, Messrs. Ganapati Enterprises Proprietor Concern, outstanding as on 28 to 26 rupees 8 lakhs 13,689. Housing loan secured by mortgaging of your jointly owned property, outstanding as on 28 to 2026, that is 10 lakhs 98,541.97, including overdue installments, accrued interest, penalties and charges, personal loan, so outstanding as on 2,67,064 only.
Are you going to pay 5 lakh 50,000 or we should discuss?
Ready, I'm ready.
Today you have to deposit that.
My lord, 7 days time.
Why 7 days? So many days were given. Why you did not remit that money?
The bank authority refused to accept it.
Where is your DD?
When I,
Where is your DD?
my lord,
Where is your demand?
with my advocate, I approached the authority to accept my 2,67,000, but the authority refused to accept it.
No, why
unless
2 lakh to-
until the entire amount is paid.
Now, where is your DD for
You
2
must
lakh?
have prepared it. When you want to-
By cash, not DD, cash.
Cash?
Yes, my lord.
Where from you brought cash?
Before the bank authority,
Cash you brought from where?
2,50,000 cash you brought from.
Which place? How you brought it? How you generated that?
borrowing from my,
Who give the names of borrowers?
my lord.
We'll direct the police to investigate whether it is true or not. Give the names.
From whom you
Well,
have
I,
borrowed?
well,
You are playing fraud on the bank.
No,
You
no,
want to
no,
take
I'm
fraud on
ready to
the
pay. I'm
court
ready to
also.
pay. I'm
Where
ready-
is your DD?
not DD, my lord.
Where from you
I'm
got?
ready to pay. I'm ready to pay, ma'am.
No, from whom you have got? We will direct investigation by the police.
Well, I will.
Call- where is our,
I'll contact my
Mr.
client.
Monty, ask your SP to investigate everything and give a report.
Pay within a time, by that will suffice.
But he is well done. You go on arguing like ties, we are very only lying.
My lord.
You are
Giving a hint out of that.
You are doing it.
No, ma'am.
You, what you feel?
5 days time, I will.
We are full.
No, ma'am.
We could make the bank full and the court full.
No, ma'am.
Month of April.
Requested only 5 days, my lord. Requested only 5 days.
Tomorrow, money should be paid. Otherwise, the auction stands confirmed.
Oblige. Oblige.
By our order dated through DD, no cash. Through DD
My lord.
23 to 2026, we had said as a next paragraph. Learned counsel for the petitioner repeatedly submits that when his client, along with the copy of order, went to the bank to pay, the tender was refused. First time. However, he has not produced any proof such as the draft, the bank draft, nor such other things. First time. Learned the panel counsel appearing for the bank vehemently refutes the assertion, saying that not only he did not pay, he did not care about the notice issued by the bank on 3/3/2026. First of all, he also tells us that the petitioner has borrowed 2 more loans.
3 more loans.
3 more, totally 4.
4.
3 more loans. And nothing is stated about the same in the writ petition. You have not said anything about other loans.
Yeah, house loan. Not step.
You are a risk-taker. First off, he tells us.
Yes, my lord.
See,
Yes, my lord. The father of the petition is
you are a money puller of the bank also. Not only that. He tells that on that ground alone, the petition is liable to be dismissed by the suppressio veri. Be that as it may. First, next paragraph. Consistent with the submission of learned panel counsel appearing for the bank, petitioner is ready and willing to credit a sum of rupees 5,50,000 to the OP bank within 3 days. Within 3 days, through a bank draft or RTGS, failing which the petition would stand rejected, maybe with costs.
This shall will be confirmed. Shall will be confirmed. Shall.
Eventually, the auction of the security property that was held on 4/2026 may be confirmed. First off, call this matter next week. Next week, but I have to let him show.
Yes, don't mind.
Print that also.
Nothing will be.
Nothing will be watching. What? Nothing will be.
Even
Action is taken.
Item 12, 5336 of 2026.
Yes.
My lord, 12 and 13, your lordship, the writ petition was dismissed. It seems they have filed a petition for recall. Thereafter, they had filed another writ petition also, which was also, your lordship, have given them liberty to approach the DRT. They have approached the DRT. This case is pending. Actually, auction sale was there, which has failed, and the CJM's order. Both are subject matter of the later writ of petition. Now in NCLT also, they have filed petitions under.
Where is your friend? No,
No,
without him, if you make submission, how you will be able to?
My lord, it seems he has filed a miscase for recall of your lordship's order, which your lordship has disposed of as withdrawn. I don't know. Neither have I received the writ petition copy nor the miscase. But the fact is, it is posted on 17/4 for final hearing of the petitions filed under Section 10 by the loanee, and this person who is the guarantor. He has also filed a Section 94 application, which can be filed by guarantor. They are all tagged up. It was on 6th. On 17/4, they are fixed for final hearing before NCLT Cuttack.
Final hearing.
Yes, I have filed my
So
reply.
action has not taken place.
Action has failed, but CJM order is staring in the face, but they have not moved the NCLT.
Now, one more point. I did not find any judgment on this.
Pardon, my lord.
Where the bidder, highest bidder, does not come forward to pay the entire money under Rule 8,
Rule 9(4), my lord.
9(4). Because of just Honorable Apex Court judgment.
Yes, Union Bank of India was
We're asking,
Sorry.
telling you. What would, suppose that money will be forfeited?
My lord, if he doesn't pay, it will be forfeited as per the
Forfeited.
security interest rules.
Correct. Well, forfeited means it will not be credited to the account of the loanee also. Because it is his money, it goes to the bank. That's all.
So there is a decision of 2000.
This aspect at all. At least 50% be credited to the
On this point, my lord,
undue enrichment.
that unjust enrichment were raised in a case in 2023 before the Supreme Court.
That is
That
rejected.
decision, Supreme Court took note and told it is not unjust enrichment because by operation of statute of
It
law,
happens.
it has happened. So there cannot be a question of that very point was raised, my lord. That it's of 2023, that decision fails me.
But it
before-
remained with the bank. You don't think
Yes.
that it should go to the
No.
government estate or
It will not go to anyone, it will remain with the bank.
But at least over the expenditure, the bank has recovered. At least that expenditure should be attested at the matter of some statement which should write that. No, such it is also. You bring your friend. You will not come.
I don't think so, my lord, because seeing the totality of the circumstances, your lordship will probably dismiss his miscase for recall. see before the subordinate tribunals, especially before the NCLT.
Whether your friend is here or in his absence, you will not pass any order. That will be unfair. Therefore, you bring him or you will have it next week.
Yes, my lord.
Call
My
this
lord may call it on next Monday.
We'll record your submission that auction has failed.
Yes, auction has.
Panel councillor appearing for the bank submits the auction that was held on.
My lord. First filing time. I am extremely sorry.
May I pardon to mention, my lord?
Having not materialized.
26,
Has not
326.
been held on 26/3.
Fixing the auction on 26, 326.
Has not been held. Has failed. For want of
Bidders.
submission, the front of bidders.
There was no bidder, my lord.
For want of bidders. First of all, in view of that, call this matter next week.
Hello.
Next week, all right?
Yes, my lord. Both the matters are same, my lord. 12 and 13.
Call
Same
together.
set of facts.
Call these matters together. Okay.
Item 14, WBC 103320.
Now he had challenged an auction notice in this matter.
My lord, in the earlier, he had challenged the auction notice and the order of the CJM. Your lordship gave them the liberty in the subsequent reach, which I was showing to your lordship, sorry.
To go before
DRT. They are filed before DRT. Those petitions are pending. The matter is pending also before NCLT. Filed by this person as a guarantor under section.
You bring him, we'll pass it over. There is no reason to keep this petition pending.
Section
Bring
9.
your friend.
This is the item.
You give number, phone number. You call that line.
I'm giving the number.
You give number, we'll call you.
May I pardon, my lord?
Yes.
My lord, item 14, Mata 305 of 2025, my lord.
14.
It is not.
Yes, ma'am.
Come with. Yes. Pass over those matters.
Yes, sir.
Okay.
Item 14,
May I please?
WBC 103320 of 2026.
My lord, there is IA for modification of order dated 6/4/2000.
What modification?
My lord, on the last occasion, your lordship please to direct the order that the 30% of deposit within 3 p.m. that on the latter part I submitted before lordship the incapability of the petitioner. So my lord was pleased to recall that order, but that order at that time already typed or uploaded. So my lord stated that if I file on IA, then the order may kindly be recalled or
Not recalled, will be considered.
modified. My lord, I pray that time that similar order passed to the as the connected matter 103333 of 2026.
What is that order we have made?
My lord, that is in my para 4, my lord, is that issue emergent notice to opposite party by speed post returnable within 3 weeks. Requisite shall be filed within 1 week and the scheduled auction may be proceeded. However, the same shall not be confirmed and no sale certificate shall be issued.
Other read.
Other read. So my lord,
But that order we cannot pass. Because we will put the auctioner under the tension. Unless you deposit money, we will not give that order.
that time submitted and
We had
please to
on 6/4/2026, we had said as under while disposing of application in IA number 6271 of 2026. First one, next paragraph. Now the petitioner has come forward with the application in IA number so and so supported by the affidavit seeking recall of the said order. First off, counsel for the petitioner submits that if that his client is not in a position to make remittance in terms of the order dated 6/4/2026, and therefore, if auction that has been held in respect of the in respect of the security property, if is made subject to outcome of the petition, justice will be meted outcome. First off. However, when asked as to whether his client to show the bona fide by making some remittance towards the outstanding dues, even for that, the counsel says that counsel pleads inability. First off, next paragraph. In the above circumstances, the application is rejected. Next,
My lord, I beg your
and as a consequence, petition is also rejected.
time is, during that time, there is 1 hour only left for that.
What
time.
can we do? Because it's a
Well,
public auction. If we interfere in every public auction, then tomorrow nobody will come forward for buying the property in a with reasonable price. Everybody will say song and get the property. That will go against him.
There's some time stipulation, only some time.
Petition is also rejected. Next.
I beg your pardon.
Item 15.
I am sorry, my lord. Item 1213, I talked to the lawyer for the petitioner. He told he's outside cut-up and is afraid it will be taken up on Monday.
Monday.
Yes,
All right. Call this matter
both madam,
On
12 and 13.
on 22nd. On 22nd. Let it come on 22nd.
My lord, as your lordship pleases.
Item 15. WBC 21703 of 2017.
15 minutes be taken up by this.
15.
Impugned order is at
What is this matter, brother?
72 at page 13.
Huh?
Challenging the order of the State Administrative Tribunal.
15. Not ready. All right, call this. When do you want?
Order dated.
What?
Order dated
Your order. Your petitioner.
2017.
2017.
Yes, not.
Into the process.
Why? Brother has passed that.
Yes,
on?
yes, that is the question he has pointed out. That.
So I will from Caesar to Caesar's wife. I'll push this matter before a bench that does not comprise of brother. Yes.
Can we have this month, my lord, exactly?
Huh?
So delay when 2017, but in the meanwhile, the petitioner has
But
replied.
correct, my brother's order, how
Yes,
can we
that's
pass
that I understand, my lord. I'm grateful that, but
Let us.
we,
Item 16.
Yeah.
WBC 30857 of 2023.
Yes,
I'm before your lordship,
yes.
as I did not get relief in the honorable CAT on original application number 594 because
What
it
was your
contains-
case? What was your case before the CAT?
I retired from AIMS after serving 5.5 years in AIMS. Prior to that, I was in military and retired as commando in the Navy.
You were in defense service how long?
But about 32 years.
22 years. As a doctor?
Doctor. Professor of microbiology in the AIMS, served for 5.5 years. As per the policy of the government, my pension amount was being deducted when the pay fixation was done in AIMS. After joining AIMS. But when I superannuated, my gratuity amount should have been calculated in accordance with the emoluments, total emoluments. What the opposite party had done in that case, they deducted my pension amount from the emoluments.
Deducted means discounted.
Discounted means that they were deducting my pay from the total pay I was getting in AIMS. But when I superannuated and eligible for gratuity, my gratuity amount should have been calculated based on the total emoluments without reduction of pension amount. That is in accordance with the Rule 31 sub Rule 8.
How the court tribunal has treated this aspect?
Tribunal gave the order.
Please read.
I'll just read.
How tribunal has treated this argument?
Just two. My lordship, just may I? Sir, may.
Your review petition also came to be
Review
rejected.
petition also rejected.
Where is the ground on? Where is the
Page 8,
reasoning?
Page 8 of the petition.
That's the only point.
They rejected my, but I wanted relief because
Relief can be given only in accordance with law.
yes,
Therefore, you have to show the law now.
Yes, my law, I am entitled to gratuity.
You have made the same argument before the tribunal, na?
Yes,
Now, how it is treated?
the tribunal gave orders.
Read.
I will just taking one mistake now.
Mr. Paddy, which paragraph discusses this aspect of the argument?
Pardon?
In this, they have discussed in paragraph 4.
Paragraph 4.
If in RA or review application order, that is.
Now go to the original order.
Original 85.
But he is not challenging the original order. He is challenging the review order. Technically, is not met in rule, that's why.
Review order, if it is a detailed order, the original order.
Original order,
or just
page
set to-
57 Lakshmi. There is Lakshmi come the third paragraph.
If,
Page 57.
Mr. Paddy, if original order is completely discussed by the court in the review order, then doctrine of merger applies. Therefore, when you are making submission, with little having knowledge of law will help you.
Yes,
Which is that Muhammad Nuh
the learning process I must learn it so.
take down this judgment instead of making unnecessary submission. Muhammad Nuh versus state of UP. Since a broad-based reading is not there, all these problems you face. Yes.
I've got the order of the original order. Learned counsel for the application submitted that the applicant who had retired as military doctor was serving AIMS from 23rd February 2013 to 31st August 2018. And was entitled to second gratuity, that is 7,11,906 as per provision of law. But praying for following reliefs, admit original application, issue notice to respondent as to why they are ordered. Initially, they had refused me that you are not entitled.
When you are reading, don't argue.
What?
Reading means reading.
Pardon. And pass any order, direction as deemed fit and proper in the interest of justice for release of gratuity amount to rupees 7,11,906. Learned counsel for the respondent submitted that the applicant was not covered under Gratuity Act, but under CCS Pension Rules 1972 and is not entitled to gratuity as per Rule 19 of CCS Pension Rules, but Rule 10(1)(b) of CCS Temporary Rules 1965. He submitted that as per the said rule, the respondent have calculated and paid the applicant a sum of.
We have read it now. Mr. Paddy is right. Muhammad Nuh is not applicable to this case because the treatment of the subject review is on maintainability. It is rejected on the maintainability and therefore merger will not apply. Therefore, you should have challenged that order also. Now we will give you time if you think on that direction.
As per your lordship.
No, not direction. This is for your benefit. We are
In
doing
the interest
some
of justice,
concession.
your lordship has got inherent power under jurisdiction.
We have no inherent power that way. We are
226.
treating the order of the tribunal. It is 227.
But actually, the order is erroneous in view of the affidavit given by the respondents.
That order you have not put in challenge. You have put in challenge only the review order. Review order does not treat the matter on merits. Therefore, party is right in saying there is no merger. So we'll give some time to you. You reflect on that and do something. Otherwise, your petition will be dismissed now. Or you want dismissal?
No.
Then call this matter after 3 weeks. At the request of counsel for the petitioners. Next.
Item 17, WBC 23457 of 2024.
My lord, in this case, the affidavit is required to be filed by the.
Today we are filing. There was little
Call up.
modification.
At the request of party finally. Next.
Item 18 has been adjourned. Item 19,
Today will start.
Yes.
WPC 4007 of 2026. Item 19,
No.
2 weeks he has to file affidavit. Nah. You serve a copy and after affidavit on the print.
Today, on the course of the day, will start.
Okay. Yes.
In fact,
Yes.
Naji had argued 2-3 points. There is some more other points also. Today to assist your lordship, I have just
jotted down the bullet points in a piece of paper and the judgments I am going to sign.
They served a copy of your note on Mr.
Just
Mohan.
bullet points, my lord.
They served a copy on the other side also.
So the correction period. But let me place it. I'll correct it and give it. Okay. Little corrections are there.
But we didn't receive any instruction, my lord, because killing the post sign, that's right.
Let us see. Let us see. Let us see. You were given a first time when notice was given to you. First time when notice was
given long back, madam, February 2000.
Then we need not wait for your objections. Yeah. This is on a consideration of application for entry prayer. Yes.
Lord, I had
That was
said,
made clear also.
Lord, I had submitted with regard to passing the order without asking any readings. That point I have already argued for my lords. I have cited the judgments also.
Your first point, where are my notes? Our notes.
Correction period, I think, was I hope your lordship do not require that writing even.
Sometimes it becomes easy to see. Reply to your reply in detail was not duly considered.
Not considered at all.
So non-consideration and non-application of main coupled together.
Not assigning
29Q and 29U
that
are not kept in view.
right.
Then clarification letter by the Labor Department,
1810
that has not been
been
adverted to.
considered.
All right.
Now, Lord, impugned order without assigning reasons, I have given judgments. Today also I'll repeat them.
You said consider. What is meant by consider?
Meaning of the word consider.
Then second one judgment is the thin line between quasi-judicial and administrative because of Eki Kraipak, and one more judgment you cite.
That's saying that in the administrative orders also they are required to assign reasons. Otherwise, that is the heart and soul. Regency is the heart and soul of an order. But my third is, if the lordship would see the impugned order.
Once again, Mr. Rathod, the counsel appearing for the petitioner are just the following points seeking invalidation of the impugned. First one, to the Shokas notice, petitioner had sent his reply in detail, taking up several contentions, and that the same have not been met in the impugned order. Therefore, it is bad for non-consideration of relevant material and also non-application of mind thereto. Next point. The true pith and substance of Rule 29Q, Rules 29Q and 29U of mining rules.
Mining rules.
Mining rules.
Yes, my lord, that is Mines Rules 1955.
Mines Rules
1955.
55 have not been adverted to. First off, had they been common, the impugned order would not have been made. 3.
My third point is,
Letter, the impugned order ignores a very important material, namely the Labor Ministry's letter dated 18/10/2021, which clarified that the exclusion was INTEC specific,
yes,
and not to the other trade unions affiliated thereto.
Other individual trade unions are
Other individual trade unions affiliated there to INTEC. Next point. For non-consideration, cites apex court decision in, they give those judgments. He is, he presses into service the decision of apex court in Chairman Life Insurance Corporation versus Masilamani, para 19.
2013, 6 assistant.
Further, he adds that in our administrative law jurisprudence, the difference between judicial and quasi-judicial functions has withered away since A.K. Kraipak to consider that Kranti Associates versus Masood Ahmed, 2010, 9 ACC 496, and therefore reasons need to be assigned even when decision has overtones of administration as distinguished from quasi-judicial. Then what other point?
Lordship will find from page 23 the impugned order.
The first judgment that Masilamani said.
Page 23, annexure 1.
The first judgment. 2013, which says CC 530, para 90. Consider. Consider word of it. Yeah. Yes.
Lord, your Lordship will find from the impugned order, page 23. Primarily, your Lordship will be pleased enough to find that the impugned order has been passed based on opinion of the Advocate General.
Yes.
Based on opinion of the Advocate General. There are two things here. But opinion is not a mandate of law. That is settled position of law. I have given a judgment also.
Why judgment? Opinion is.
For my safety, I have given one.
Yeah.
Opinion is not the mandate of law. Opinion is a privileged communication between the client and the lawyer. Now, that being the position, your Lordship again has to consider whether that opinion which has formed basis of the impugned order has taken note of that 18-10-2021. Doesn't. That opinion is also part of the order. So that opinion is enclosed here. That your Lordship will find 18-10-21 has not been taken into consideration while delivering that opinion.
Right. Next point. The impugned order is mainly structured keeping in view the opinion of the Advocate General, and that the Advocate General did not advert to the Labour Ministry order dated 18-10-2021, and therefore the opinion itself being truncated would not have been the basis for making the impugned order.
Now, my next point is,
one more. First, he hastens to add that opinion does not bind. Yes.
My next point is, if your Lordship would see the pending cases, those who are either being stated by the MCL here or by other orders also, all those cases do not include this petitioner union. OCMS is not there.
Next one.
They are all with regard to the JBCCI. And
in the disputes or cases between Intec and others, petitioner is not a party.
Nor issues involved here are also issued there. Nor the issues involved here are not the subject matter of consideration there.
And further that the questions that are being examined on the floor of this court are not the subject matter of those disputes.
Right. Then my next point is discrimination. As I was trying to show you, additional affidavit, page 97.
Next point.
Lordship will see.
The impugned order is discriminatory in as much as it denies right of participation to the petitioner only, whereas to others the same has been extended.
Other minority institutions, minority unions.
Though such other institutions numerically are not as strong as the petitioner trade union, which is having highest number of subscriptions.
But this highest number of membership aspect admitted by MCL in
As
their
admitted by MC.
MCL in their affidavit, para 4, if lordship would guides.
In their affidavit filed in this petition. Wait, para. Okay, next.
1 second, my lord. Para 6.
Para six.
Just 2 lines I can please. It is humbly submitted here that even though.
No, why do you read that? You have said that. We'll read that. Don't waste time like
So
that.
nice.
Yes.
So, Lord. Then I am citing, Lord, additional affidavit, page 50, 51, 53. These are letters.
Saying?
If lordship sees. These are the letters. Your lordship sees. My point is, additional affidavit, page 50 onwards. These are the letters by which we were called upon to attend different statutory, non-statutory committee meetings of 2025, 22.
It's only now they have denied this, sir.
But my point is, by then also,
Disputes were there.
those disputes are pending. The latest is 2019 as per the MCL, civil suit in Delhi High Court. 2019 was pending. Despite that, we being the largest union were called all throughout. They are page 50, 51.
To the other first point, that disputes are not relevant question. These questions do not arise. We have said that very early.
No, coach.
No. Disputes, the word disputes you have taken. Several disputes are pending between Intec and others. 3 minutes ago you wrote that and you have forgotten. Have you taken? Yeah, what have you taken? He is not a party. That one. Add one more this one. He adds that even earlier these disputes, even earlier, though these disputes had been pending, the petitioner union, trade union was permitted to participate in many statutory meetings.
Statutory, non-statutory.
Statutory and non-statutory meetings. And therefore,
invoking Rule 29Q.
Especially keeping in view Rule 29Q.
1A of Mines Rules 1955.
Huh?
1A, that's what they have invoked.
1A.
Yes. They have invoked. Chapter 4B, page 52.
29Q. And therefore, there being no change of circumstances, the reason now given is only a ruse, RUSE, and therefore unsustainable. Okay.
But now I reply to the submissions they have, MCL is trying to make. My first,
No, they have not submitted.
No,
Let them
they have-
argue and I will give you an opportunity.
in their objection they have said, I am replying.
No, they should argue.
Let me now submit with regard to points which as per me also is relevant, my lord.
No,
There,
Mr. Ratho,
Right.
will permit you to reply also.
That's fine, my lord, that's fine. But then this is all available on record. What I'm
Then we will not have right of reply. Choose your choice is yours. You can preempt the reply, but then you will not give we will not give you time to reply at all.
I'm referring the reply, I am saying the whole reasonings, justification to defend the order should be on the basis of reasonings available in the order itself.
Mohinder Singh Gill.
That's what I'm trying to say.
Last. The impugned order, the validity of impugned order has to be adjudged on the basis of the reasons contained in its womb and not on the basis of affidavits and counters. In view of Mohinder Singh Gill versus Chief Election Commissioner,
AR
AR 78 Supreme Court, page 851.
851.
851. Para 8.
851.
Para 8, no? Correct. Lord, last submission. They have filed a counter in the connected petition. That's on record. Lord, you could kindly see para 14 of their counter. That's all.
14.
Yes. What is the MCL?
Only two writ petition. That's all
Yes.
yours only.
That is a writ petition filed by the present intervener here. The rival trade union has filed a writ petition in this honorable court seeking enforcement of letter dated 11/1/17. Let me kindly recollect. 4/1/17, subsequently relied on in 11/1/17. That 11/1/17 is a restraint order against us. That
They want to enforce.
that they wanted to enforce.
So the petition is called along with this. Whether that petition is here, no?
It is here. But it has come. Now your lordship is to
That
consider.
petitioner seeks to be an intervener in your petition.
Yes.
That any application is moved in that.
As in that has not come. Acha, that has not. I'm so sorry. That has not come. I'm so sorry. That has not come.
Only one petition is listed.
They have filed a writ petition to enforce that order dated 11/1/17, which has been further clarified in 18/10/21. But fact remains that in view of the latest order which I am impugning here before my lords, whether that writ petition will survive when it comes before your lordship will decide that, but not now. But MCL has filed a counter to that. In MCL's counter, lordship will find para 14. What the MCL is saying in their counter itself. Additional affidavit, I have reproduced that paragraph. I'll just place that, madam. Para 15, madam. I have reproduced that paragraph 14. Should I place it?
What does it say?
I'm just placing it, Lord.
Para 14.
Yes.
That's the petitioner.
That the petitioner Viren Kumar Khillar means the intervener here. Petitioner in that matter. Viren Kumar Khillar, Secretary TKKMS, represented to the GM Konya area on 31/1/23, alleging non-implementation of CIL and MCL circular regarding representation of members of OCMS, INTUC in statutory, non-statutory, bipartite, tripartite committees of CIL and its subsidiaries to which GM Konya area, OP number 6 in its reply reference number so-and-so 9/2/23 has categorically stated that the matter has been examined and neither there is any application/case pending before any court for the aforesaid purpose, nor there is any direction of any such court against the petitioner union. Under the above circumstances, there is no impediment in allowing OCMS affiliated to INTUC participating in bipartite and tripartite committees between management of MCL and workmen of all the coalfields in operation throughout the state of Odisha. Again, the petitioner represented to the GM Konya, although letter number so-and-so, raising the same issue to which GM so-and-so by answered in the same manner as before. This is their statement and affidavit before this honorable court in that other matter.
To oppose that petition, they have taken up this contention.
Yes.
That stand comes to your aid is your argument.
Yes. What I am now saying before my lords.
Next point. In para 14 of which OP's affidavits? MCL's affidavit filed in WPC number 20092 of 2024 seeking implementation of circular dated
11/1/2017.
11/1, that is 18/10/21, not
18/10 is in my favor. 11/1 is in that. 11/1/17.
11/1/17, 2017, which excludes participation of petitioner hearing in the meetings, comma. Certain averments are made to the by way of resistance to the said petition, and those averments support the case of petitioner hearing. First off, the MCL being an Article 12 entity,
Yes.
cannot change its colors depending upon
the petitions which it is called upon to make a statement in, especially when the petitions are structured on the same substratum. Okay, great. You will have a reply after they argue. So you will have a reply. Yeah. Yes.
Just 1 minute.
Yes.
Sir, can I put one judgment?
What?
Judgment.
Before citing the judgment,
So, but
cite the proposition.
was asked that question yesterday. The region must be assigned not only quasi-judicial order, but also.
No, that he has said already. It is covered by judgment.
Latest judgment, if you are
All right.
12-2, if you, it can be helpful.
Yeah.
12-2, paragraph 12-2. Vasudev Datta versus appellant versus the state of West Bengal.
Which year?
This is 2024. 24. The date of judgment is, various judgments have been cited. 5th December 2024. Para 12.2. It is settled law.
See that we have said. We have, all right, we have understood. This time. Right, friends. Mr. Ravutrai, learned senior advocate, appearing for the intervener,
Who is supplementing the
supporting the case of the petitioner, also tells us that even in the latest judgment in so and so, the apex court has said giving reason is imperative even while making administrative decisions, as contra distinguished from quasi-judicial. Okay. Write down that judgment. Oh. Yeah. Yes, sir.
And Lord, your Lordship has
Correct. Just a yes, sir.
Millard,
Yeah.
it's a cost of reputation because your Lordship has already thoroughly has been seen the record.
Yes.
But yet it's my duty to just to point out so that I will formulate my point.
Yes.
My submission is a very small submission.
Yes.
The submission is here. There are fractional disputes and still prevails. And fractional disputes in 2017 and today in 2026 that still prevails. And in fractional disputes, there were the different fora has interjected them not to participate. And they have come here earlier in a writ petition. First, they have taken the interim order against that order. And thereafter, in final, that was taken out. Interim order was not continued.
Petition is pending.
No,
That
petition
also.
is disposed of with the direction that you file a representation. And representation was disposed of with a direction that there is a fractional disputes, don't allow them. That was the sum total of AG's opinion. That was adopted as a reason here. Because your Lordship knows, I am not contesting any order, be it administrative, be it quasi-judicial, be it judicial. It should continue reasons. But it should continue. Because whatever brief reason that should be. Here, what has happened, it has been adopted. A opinion, I have taken opinion. It's my prerogative. Because I can take opinion. I have taken opinion. And from opinion, the reasons was there, I have adopted that. And that was part of the order. And opinion is also part of the order.
No, opinion part will come to next point.
Yes.
The first point you say is
Yes.
there are fractional disputes in the petitioner organization.
Yes. Your Lordship, here kindly, one more thing your Lordship point out, are two things that has to be cleared. First, there is no recognition here. Your Lordship has asked about recognition. Here it is equal treatment to all.
All. Therefore,
Yes,
recognition
yes.
is not there.
You may be 10 members,
You may be 1,000 members, but it should be same. Because the concept of bargain is no more. They are the stakeholders. They have to participate. In a sense, they have to suggest. They have to suggest for the well-being of the workers. So the workers should be in a better footing to discharge their duty. There is no question of nowadays, Millard, the bargain. In this era, that is how, Millard, the new code has come, taking out the Industrial Dispute Act. The dispute was taken out.
But Trade Unions Act still continues.
Millard, trade union, Millard, that is what I say. What is INTUC? INTUC doesn't have its own independent members. INTUC is like this OCMS. Membership all over India is INTUC because it is registered as a central union.
Federation.
It is registered as a central union. So therefore, these are people, they constitute the INTUC. They constitute the INTUC. So, Millard, he himself, Millard, if you lordship, I'll just take out first, come to Millard, the read petition, page 3, page 29.
No, 1 second. Sir, 1 second. I'll write down your contention.
Yes. Millard, I have not gone to contentions. And now I'll go to the fact, then I'll go to the last to the contentions. Contention should be, Millard, that is will be my last Millard summarization. That will be contentions.
Very good.
So what I am showing, kindly see page 29, Annex 3 of the read petition.
29.
Yes.
Constitution and rules of Orissa.
No, your lordship, can see INTUC affiliation number.
Third line.
Third line. Bold.
Affiliation number.
Yes. So they Millard, they are the INTUC. OCMS is the registered trade union in Orissa. So they are INTUC.
But the Apex Court
Yes.
has treated the idea of affiliation
Yes.
that runs counter to your argument. Take out that two judgments. What is affiliation is discussed by the Apex Court. That runs your argument runs counter to the pith and substance of that judgment. Take out that judgment.
Additional affidavit, they have also admitted OCMS is affiliated to INTUC.
Mr. Mobility, an entity is one thing. Affiliation of another entity to that entity is another. That is the pith and substance of those decisions.
Millard. Now, Millard, that is with regard to this affiliation part. Then second, Millard, I'll show to the...
Your affiliation argument is over with this.
Yes. This is the INTUC. Now, your lordship, kindly see page 98.
Mr. Mohanty, drew our attention to earlier on which paragraph, Mr. Mohanty, you said?
Page 29.
Page 29, Annex 3.
Page 29, Annexure 3.
And additional affidavit.
To contend that the petitioner is nothing but an integral part of INTUC. Full stop. Little further argument can you make on this to convince us?
Millard, kindly see the membership, a registered trade union run by membership. Membership is what? Workmen or the employees working in an industry.
They don't have legal personality?
Eh?
Do they have legal personality?
They don't have any legal personality.
Take out the 26 Act, 1926 Act. Take out that. Give 1926 Act. A trade union, I believe, I may be wrong also, trade union is a legal person.
No, trade union is legal personality.
That's what I asked you, whether they have legal personality.
That I am not disputing. Trade union is a legal and it's a perpetual body.
Correct.
Millard,
That is
That is not dispute. What I say, here, Millard, it's like they're so integrally connected. Member of one becomes member of two. Member of OCMS become member of INPC.
Is it prohibited?
Millard?
Is it legally prohibited?
No prohibition.
Then what else?
No, I'm not saying prohibition.
No, then your argument will not advance your case.
No, Millard, what I'm saying, the membership is the same.
Then, Mr. Mohanty, one more query.
Yes.
Having regard to the size of your establishment, whose duty or whose obligation
Yes.
is to ensure the recognition of the union?
Recognition concept is not there.
Not there.
Not there?
No.
You have not gone for the recognition?
No.
Have you got an exemption under?
Yes. We have taken. He has read that.
You have taken an exemption.
Exemption. And it is, that is how my lord has said equal treatment.
Bargaining is for all.
Not
All the-
the bargain word, Millard,
All
no
the-
more.
No more in the.
Yes, Millard, bargain is no more. Here, Millard, here participation in the sense,
Yes.
you come and suggest
So
what would be
participation
the
of
best
all the
working
union.
condition.
Participation
What
of
would
all
be the best
union.
working condition so that the employees or workmen, they will work in a better manner.
They has to expose the cause of the.
Yes, that is the stakeholders. So this is how, Millard 29, I'll go to 29 years. Millard, this consultation doesn't mean that I have a bargain, I'll go and fight. That regime has gone.
True.
That fight and that Lal Jhanda, that has gone.
Not true. We are not on that.
Now we are trying. So what I'm saying, a member is here, he becomes member automatically there by means of the affiliation. As your lordship says that they are perpetual body, they are the individuals, they are, so that is no doubt. But what I say, it runs, because in this affiliation runs in this manner. So this is what it runs in this manner. So
we don't agree with that because it runs counter to the jurisprudence. Well, anyway, we have argued that. This next point.
Well, next point is page 98, kindly see.
Can you spend a couple of seconds on the idea of affiliation as contemplated under the 1926 Act? Kindly take out the provisions.
No. Affiliation word is not there.
I do not know. My knowledge of this act is of my college days. Yes, till that act. Thank you.
Mode of registration is 4. Section 4 is mode of registration.
Just looking the word affiliation in the industrial jurisprudence treated by any of the high courts in the country. Just look into it. Any rules are promulgated under this act? 1926 Act? Regulations. Regulations say anything about affiliation?
I'm just looking at it. I'm just.
Any labor law expert in the court hall?
Regulation under 38 is there.
Regulation. Affiliation is that?
26 Act, my lord. Kind of a glance to the last page, page 29.
29.
The central
Power to make regulations.
This here relation code 2020, definition of trade union. Can you also look at this?
Whether Trade Unions Act is repealed, it's also repealed.
No.
No, it's not repealed. Is it repealed? Whether this act is repealed?
This is repealed. In the new code, it is repealed.
This also is repealed.
Yes, sir.
In the new code. In the new.
Then,
Appointed date.
Yes.
keep this. I have not seen that act at all. Just
This
you have
is with
to,
effect from
you
the
have
appointed
to
date.
teach the law and take the decision from us.
No, this is the new.
Any word affiliation is used in any of the regulations.
In fact,
No.
this we have given. This we have.
Your Lordship has to take it from the common law. In the absence of a definition in the statute, then Millard, what has to be rely upon the common law. The common law here affiliated. And your Lordship has rightly said affiliated. But the membership, Millard, what I am harping here, the membership of this union becomes, they are the members of the INTUs.
Correct, Mr. Mohanty. We are not against that. We understand that.
Yes. So that
By that, see, Palkiwala was a director in many, he was a member, shareholder,
Yes.
and director of many companies.
yes.
That does not affect the composition of a personality.
No, I'm not there. Millard, you don't take your Lordship to a bigger thing. I'm just saying that they are the members. Here, Millard, in Talcher, let's say Talcher is a coal field. Talcher, here the OCM operates because by virtue of his being registered as a trade union in Orissa. So there is a member called A. Millard, A automatically becomes the member of INTUC if he is affiliated to INTUC. If his trade union affiliated to INTUC, then Millard, the A here,
Becomes member of INTUC itself.
yes.
Where is the legal support for this, sir?
Millard, that this is legal. Millard, this is the general Millard, that I am saying. Millard, there is no legal Millard, that is nowhere, Millard, nowhere.
All right. Have you taken up that contention in your counter?
Millard, that's what I have said. My prayer is still pending with your Lordship to allow me.
File objections.
Yes,
Well,
I'll counter it. Because it was your, that day your Lordship said that I will take up for the interim orders. And we have not filed counter. They have filed a read petition. They have filed an additional affidavit. Well, I have not filed. That's what my prayer still there.
No, that's why but we had put you on notice that we would be taking up the matter for consideration of interim prayer.
Yes, Millard, interim is kindly see Millard interim prayer. Interim prayer in 2017. They have obtained from this Orissa High Court interim prayer. And on 13/7/2021, Orissa High Court did not extend the interim prayer. And that was disposed of. I'll show Millard those things now.
No, whether 18/10/21 letter was there before the court.
No, Millard, what is 1810? 1810 is related to 4/1 January 2017. And this 4/1 is Millard, that was considered in 11 January 2017. And 11 January 2017, Millard, Orissa High Court has stayed at their Millard behest. They are the writ petitioner.
No, your first submission. No, we are moving from this side, that side, etc. Let us go methodically so that we can put the things in focus.
Yes.
Your first contention is once petitioner trade union is affiliated to INTUC,
Yes.
it becomes part of INTUC.
Yes, Millard, absolutely correct.
Right. Mr. Mohanty firstly submits that once a trade union is affiliated to INTUC, which fact is coming forth from annexure 3 to
3 page 29
3, page 29, comma,
and additional affidavit.
the affiliated unit becomes part of the INTEC, and therefore the dispute between INTEC and others would be a dispute to which petitioner also would be a party.
Yes, I am grateful.
First, this he submits on the general view of idea of affiliation, and he adds that affiliation as such is not spoken of in the law relating to new law relating to trade unions,
Nor in Trade Union Act earlier.
nor in 1926 Act. First. Two yes, two H, two H. Definition of trade union.
Trading means any combination, whether temporary or permanent, or primarily for the purpose of regulating the relations between workmen and employers, or between workmen and workmen, or between employers and employers, or for imposing restrictive conditions. The conduct of any trade or business that includes any federation of two or more trade unions, that which comes under federation.
But affiliation is one thing, federation is another.
Another one, that during the limited.
What Mr. Manti says is,
There is a federation is there. All the centrally trade union, which is formed federation, where the different registered trade unions are affiliated. But minor is saying that you are point out. Affiliation, the formal association of registered trade union would be larger federation of the central labor organization. Just like INTEC, my non-friends association who are affiliated to.
no, Mr. Manti is saying, the dispute need not be between the petitioner and others. If a dispute is between INTEC to which petitioner is affiliated, that also partakes the dispute between that is his submission. Therefore, we have excluded them.
But petitioner sole admission is that they are still affiliated to the.
No, based on that only he is saying.
That is what is
Based upon that only he is saying now. Because they themselves have said that we have affiliated to INTEC.
I have explained my plan that in the central level, there are my lot.
Let us see. We will not interrupt him. Already we have interrupted him more now.
That's it. Yes.
We'll come to you. First off. Therefore, the first contention of the petitioner on behalf of the petitioner, that there is no dispute as such between the petitioner and others, nor is petitioner concerned with the dispute between the INTEC and its other units, is not correct. That's what you are saying. So there is a dispute. This dispute partakes the character of dispute because of affiliation to INTEC. You got that judgment? It may lend credence to your argument. Give that. Just
Give me.
yes, give that. Which is that?
when new regime comes, it takes time to comprehend what is the new thing.
Yes.
Mm.
Because new regime is a Millard now, like Millard, suppose this organization, I need not give. Millard, what has happened in High Court? There is no strike. Supreme Court has frowned upon that. Why? Because the very simple reason is that you are here to work. You work and say your grievance, that these are my grievances. Then we are there to solve it. And we will say that there should be better condition for you to work. So that the work ability will go on. Now we are here because we are competing in world level. We are no more now, India is no more here. And there cannot be everyday working loss or working hour loss. So this bargain is not. Millard, I will come to 29Q, Millard. What is the 29Q purpose, Millard? Your Lordship will see, Millard. Millard, it is not that I will put my hand down and saying that, see this. No. That regime has gone. The regime is here. Say who are the best. So the best, so that we can find out here if your suggestion is good. Yes, that can be accepted. So that is how, Millard, we have taken out the recognition part. Earlier recognition means one oust others. Even if there are, Millard, 5 operative unions, they are small in number, yet they have no voice. Because I have mastered the Millard, the mode number. I have mastered the mode number, therefore they should be all out. It is not by the mechanism of the employer. It is by mechanism of the employee. The workman itself takes out the other workman. But what we did here, because we are, Millard, we are in an essential service. We are running the lifeline. Electricity is no more, Millard, that we are part of 21. Electricity is nowadays, Millard, article part of 21. Right to life. So therefore, and what we are doing, we are, Millard, operating the mines to give the coal to the power stations who will produce the electricity. So therefore, it is so essential. So here it is not come and put your thumb down. You come and put your shake hand. So that, Millard, that would be a number of, Millard. So that number of things here. I will come, Millard. Millard, it has to be looked into in a different one. Why we say we are not against you? Because in Orissa High Court, he has attempted. Has he got 11-7 order struck down? No. Has he taken 4-1-17? 4-1-17 is, Millard, referred to 11-1. Has it gone down? No. 4-1-17 has been referred to in October 21. Nothing but 18 October 21 is nothing but that is 4-1-17. He could have earlier. So, we will continue after this.
Just look, Mr. Monti, you may look.
Yes, my friend should give me. My friend, young friend should give me. Because there are very many things which we do not know.
To me also, Lord. To
Yes.
me also.
So
To me also.
So that.
In the list. Let me some of the.
For the appellant.
I was
Some other, because this is a marathon matter.
that
It will take some time.
any date for
Next week.
Next week.
Next week, any day.
Next week.
I refer item number 24.
24.
Next.
Next week, all three.
Item 7 was passed over. Your Lordship just wanted to know whether the auction has been, final payment has been made by the purchaser or not. I have got that information on 31st March. He has made the final payments.
But
Item
you
7.
said, we have now, the auction has failed.
No. That is in item 12 and 13.
Item number 7.
Item number
7 was passed over on a short point. Your Lordship wanted to know, because he had paid 25%, whether the balance amount has
he
been
paid
paid
or
or
not. He has not paid.
He has paid on 31st March.
Paying order been passed. No, not passed any order.
Item.
So we'll call this matter next week.
As my Lord pleases. Lord, it can be.
Next.
No, it can be, if subject to Lordship, it can be disposed of, saying he may approach the alternative remedy now.
No,
I am,
you are for the petitioner.
Nice.
You approach the
DRT, my Lord.
DRT. Why we should interfere? There is a Bafna judgment, na?
Bafna is there, even your Lordship will not interfere in surface matters.
The sale intimation letter was communicated to the petitioner, my lord. The balance amount was supposed to be paid by 11th
You
of
take up that contention before the DRT.
My insistence, my lord, my submission is that the petitioner is ready to pay the equivalent amount, my lord.
That you take up there only.
My Lord, once third party rights have accrued by virtue.
No,
of
you
the
take up that.
certificate,
We will not say anything about that.
I bow
You
down.
take up that contention before the
It is
DRT.
open to him, my Lord.
In both the petitions, we will make that order.
No, one case, item 7.
One.
12 and 13, your Lordship had handled.
Okay. But right now, the challenge by the borrower or surety?
No,
Borrower is to kindly be seated. Mr. Monti, kindly be seated. Is to the coercive proceedings of loan recovery constituted under the provisions of Surface Act 2002. First off, both the sides argued very many points challenging the said proceedings. First off, however, we are not inclined to interfere with the matter in as much as the petitioner has got alternate and equally efficacious remedy of approaching the DRT for working out his grievance, for which he has presented this petition. First off, in the above circumstances, this petition is disposed of, reserving liberty to the petitioner to avail the statutory alternate remedy which learned panel counsel appearing for the bank has indicated
Given the decision.
within a period of
10 days.
within a period of 2 weeks. Within a period of 2 weeks. First off, all contentions of the parties are kept open. First off, if petitioner avails the remedy within the period as mentioned above, the issue of limitation would pale into insignificance.
My Lord, otherwise from sale certificate, there is a period of 45 days which is
Correct.
applicable.
But when did you inform me? When did you inform me?
Not been informed.
Today I have informed, so but he has not
Therefore,
yet.
we have said that.
Yes, ma'am.
This just start. Yeah. This peculiar order is made, keeping in view the peculiar circumstances of the case, with no intent to make it a precedent for other cases. Okay.
With permission, item 20.
Yeah.
Item 20.
Wait, we are in the mid of the hearing now. Allah, senior advocates are appearing. Yes.
Item 19.
Yes.
4007 of 2026.
Yes, Mr. Modi.
Yes, my young friend has.
I looked into that. That may not be of much help to you, perhaps. It may not be of much help to you. I also looked into that.
Help in the sense, they say that if it is affiliated, the affiliated
workman of that will be entitled to be espoused that way.
Yes, that means that shows that there is a relation.
Yeah, relationship is of course affiliation in a kind of umbilical cord. It is. That's all.
Yes.
With that it ends.
Yes, that is. The whole purpose was to show to your Lordship was that in the trade union, there is that cord runs. That cord runs from here to Delhi. That cord runs from here to Delhi. And you said Delhi. So this cord runs from here to Delhi. That's all. So, Millard, I stop it there. Now, Millard, your Lordship, kindly see they have shown first the page 98.
28.
Page 98. This is the letter dated 11 January 2017.
Yes, sir.
This letter was shown to your lordships yesterday, and they have said that this letter refers to 4.1 last. Therefore, necessary instruction may please be given all concerned. Just that
Second para, fourth line.
second para, fourth line. It refers to 4.1.17. Yes. 4.1.17 letter they have also shown to you, lordship. That is page 100.
4-1. Second. 4-1. That is 4-1-70.
This is to three factions that has been mentioned. Dispute between different factions. Then they have stated that this is what you will not be allowed. This 4.1/2017 letter again referred in 18/10/2017 21.
Same letter.
Same letter. This letter has been clarified according to them in 18/10/21. So now my humble contention before lordship, kindly turn to paragraph 17 of the writ petition. Page 15.
Yes.
Well, here, my lord, the petitioner's trade union, the present
It had filed WPC number so and so.
number 5603/2007, there was clear interim order passed by this Hon'Ble Court directing stay of operation of order dated 11/1/2017, that is at page 98. Page 98 was the subject matter, and that was stayed first. Kindly see. Subject to the condition that petitioners union will not be participating in meeting of JBCC. Copy of order dated 26/4/2017 is passed in WPC number 56 annexed at 12. Kindly turn to 114.
114.
114 is operative portion. It starts from 108, annex at 12. Operative portion is at 114. Accordingly, till next date,
Operation of the impugned 11/1/2017.
relates to subject to state condition that the petitioner union will not be allowed to participate in JBCC. But here he can.
What is meant by there is stay, but petitioner union will not participate?
No. Stay means so far JBCC concerned, they will not. But so far others, they will participate.
Where others were also parties to this? Others were not parties to this.
No. Others means he will participate in the bipartite joint.
Except in the JBCCI, all other meetings he will
participate. That was the stay order granted. Now, my lord, this writ petition has been disposed of with an order dated 2009, 13/7, 21, 209.
Page 209.
It is disposed of on the ground that it has become infructuous.
The writ petition filed in the Delhi High Court become infructuous. Then they said that Mr. Rath submits para 3. Petitioner shall submit a fresh representative grievance petitioner to the opposite party Secretary, Ministry of Coal, drawing attention to all subsequent development and asks for inclusion in JBCCI 11 to exercise the Constitution. In view of above matter, permitting petitioner to make fresh representation, the opposite number so and so suggested disposed of. So here, my lord, this order dated 26/4/2017, that interim order court did not extend.
No, matter itself is disposed of with liberty because
Yes,
the case was structured, premised on
Yes.
the pendency of a case in Delhi High Court.
my lord.
That Delhi High Court case itself was rendered infructuous.
Yes,
Therefore, they said,
yes,
we will make a representation,
yes.
and if the government considers
They,
that representation,
there is another catch. 4/1/2017 order, which he is now stating with regard to 4/1. 18/10/21 is nothing but clarified 4/1/2017 order. 4/1/17 order, he could have agitated that. Those points could have been agitated.
let us see 4/1/2017 order,
Yes.
and let us see the 2021 order.
Yes, 21 order is, my lord, page 212.
203.
Sorry, 203, sorry. 203.
Learned senior advocate Mr. Mohanty, appearing for MCL, submits that petitioner's earlier WP number, which is that WP number?
85
Yes.
5603.
603 or 17.
5606 of
2017,
which had laid a challenge to the order dated 4/1/2017.
11/1 refer to 4/1.
No, what was challenged there?
Challenge to 11/1.
11/1/2017.
17.
Having been disposed of without interference, comma, petitioner is restituted from laying a challenge to the order dated
Dated 4/1/2017.
no 18/10/2021,
21,
which is
Yes.
nothing but a replica of
Yes.
replica and reiteration of
4/1.
4/1/2017.
Yes.
And another letter is
11/1.
11/1/2017.
17. Yes. So, my lord, now, my lord, this part is over. Now, kindly come to the show cause notice, page 212.
Yes.
In show cause notice, they have stated that there is no legal compulsion for inclusion of INPC in bipartite and
Well,
tripartite.
annexer, sir,
Annexer,
give
Miller,
us
page
annexer
17.
17.
Miller, yesterday he has all shown all these papers.
Correct, correct.
That is, so your lordship must have seen. There is no legal, second paragraph I am reading. There is no, quote second line. There is no legal compulsion for inclusion of INTC in bipartite, tripartite meeting MCL. Therefore, order of consultant, Ministry of Coal, dated 11/1 stands. 11/1/2010. In fact, according to him, this 11/1 is already gone. 2017. And thereafter, you may submit your written representation, if any, preferable within 10 days. So this, my lord, now
Page 23.
page 23. After he has given his reply, page 23 is the order. Page 23 is the order.
223.
No,
Only 23.
Only 23.
Annexure 1.
Annexure 1.
Annexer 1.
That's the impugned order. They are challenging this order, my lord.
This is more intra-departmental communication because it addresses the general manager, all areas, MCL. It is not addressed to petitioner.
No,
Yes.
Milord, it was. Your Lordship is correct, but
Copies might have been sent to them.
copy has been given to that. Copy says the General Secretary OCMS Pratilipi, that is page 24. Copy. In fact, your Lordship is correct. They could have. So this is a fault. This your Lordship may say once again they may. Now here, Milord, your Lordship kindly see the third subparagraph. Further, the General Secretary OCMS was given to an opportunity vide this office letter number so and so to represent his case as to why OCMS should not be disallowed from participation in any statutory, non-statutory, bipartite, tripartite committee of MCL. General Secretary OCMS vide's letter dated 21/12 addressed to the General Manager. He submitted his reply. His reply was considered. In the above letter, along with other relevant documents, they were referred to the Advocate General, Government of Orissa for
Who
opinion.
considered the letter?
Milord,
The decision was taken by whom? Who made the decision?
Milord, the decision has been made by this Mahaprabhandak,
Means
means the General Manager,
General Manager of
MCL.
Where is that?
Milord, this is Milord that last.
Mahaprabhandak.
Yes.
Who should make the decision in MCL?
Milord, here the notice, the so cause was issued by the General Manager.
General Manager.
That Mahaprabhandak. And he has given this letter. Here, one defect what your Lordship has pointed out. While addressing the letter, he should have been addressed, but he has been posted at the copy. That was the defect that your Lordship may either to, if your Lordship is not accepting, then it can be sent back. If your Lordship is not accepting that, no, it has not been addressed properly, then it can be sent back. So if your Lordship say that this is an irregularity which he has not pointed out. He has accepted that this is a letter
Addressed to himself.
addressed to himself. He has pointed out. He has accepted that. Now, Milord, in this, Milord, kindly see the above letter along with other relevant documents were referred to the Advocate General, Government of Orissa for opinion, and Advocate General vide opinion dated so and so, copy enclosed. Copy, Milord, here the page 25 and 27. I will read out, Milord, that copy enclosed. Then they have quoted. In my firm opinion is that there is no compulsion for inclusion of OCMS in bipartite and tripartite meeting of MCL. Therefore, OCMS union operating in MCL can be disallowed for participation in statutory, non-statutory, bipartite, tripartite meeting of MCL, unquote. In view of above, it is conveyed henceforth OCMS should be disallowed from participation of statutory, non-statutory, bipartite, so and so. Here, Milord, I have no quarrel with regard to reasons. What has been here done? They have adopted the reasons given by the AG.
That itself becomes your reason.
Yes.
That's the point that is made part of the
yes. And the opinion also that has been enclosed. And in opinion now kindly come to page 26.
But text of the order, Mr. Mohanty.
Yes.
Text of the order. This argument is very attractive at the first blush. But kindly see the text of the order.
Yes.
It amounts to blindly abdicating the decision-making power to the Advocate General. He could have said, Advocate General has said, we have looked into that. We agree with that.
Milord, that is one way of looking. Milord, here your Lordship dealing with an administrative matter. They are not that trained. They are neither post-judicial nor they are judicial. So, Milord, only your Lordship has to find out, yes, whether that is some reasons or not. If the reasons are not adequate, then your Lordship will set aside.
No, adequacy we will not go into.
So
reasons, whether due application of mind.
Milord, according to me, once somebody is adopting.
Voting is not adopting.
No. Milord, first he is considering, then adopting. He is considering the opinion, then adopting.
Where is the material to show? Intrinsic
Milord,
material to show that he has considered.
Milord, that is what they have said. Na?
Where is that? Which paragraph?
No, paragraph the above letter along is so and so, then copy and quote, then this. In view of above. In view of above means that.
In view of the above, it is conveyed to you.
No, no,
Not it is
no.
decided.
In view of above means we are accepting the reason and we convey you.
Perhaps language has to be strained.
Milord, if your lordship says the language falls short of your lordship's requirement, then Milord, it is up to your lordship. Milord, I can't improve upon the document. I can't improve upon the document. Document says so. And kindly see the what is opinion. Opinion is at page 26. Milord, 25 to 26, Milord, I will relevant paragraph I will read out.
Your general manager qualification is what?
Milord, they are engineers.
Do you have any info? Can you instruct one of your? They may be generally trained officers.
No, they are Milord,
chartered
I have
knowledge with ICWAI. Like
no,
no ICWA, nothing.
No. They are generally, they are the mines engineers. They are being promoted in mines department. So like this, and these are the HR people. So, Milord, if your lordship feels short that this reasons is not adequate, or this reasons is fall short of, or this reasons is that is not in completely encouraged. So all these things, Milord, open to your lordship. Milord, I leave it to your lordship that at that point. I will not, Milord, join issue with your lordships on that, Milord. I will not. Milord, what has been, Milord, in essence, Milord, I wanted to say, on the right, I have stated that the essence is that is a factual disputes.
Faction
disputes.
There are factions and
yes. Kindly see page 26.
How that we'll assume that we'll agree with you now.
Yes.
There are factional disputes.
Yes.
How that will come in the way of calling them to participate?
No, Milord. What will happen, Milord? In that INTUC itself, Milord, the three factions. So whom to call, whom not to call?
No, they are here. You can call them.
Milord, I'll come to that 29Q. Milord, what is the calling, Milord, here? Your lordship is that they are saying it is not calling means that I will your lordship, I'll come to 29Q. One provision they have shown.
Consultation.
Consultation.
Should be consulted.
No, consultation for what purpose?
For sending 3 workmen.
No, for qualified 3 persons should be Milord consulted.
Correct.
So that means suggestion will be invited.
Correct.
From that suggestions, the management will appoint. And here, Milord, in 22 mines, it is already there. There is not that there is a vacancy, somebody calls for, nobody is calling. If your lordship will regard to find out his assertion, so far the 23Q is concerned, para 15 kindly see. Para 15. Para 15 at page 14. Go to 14. The right of representation is statutory right. Mines Rule 55, Rule 29Q mandatorily requires representation of union having largest number. This is all. Instead of largest number, because there is no recognition, no largest. We are calling for everybody. All the unions you come and suggest. And here, Milord, kindly see what is 29Q. If your lordship will read 29Q once again.
Somewhere it is reproduced.
Yes. 20.
101.
No, your lordship, kindly go to the book, Milord. Mines Rules.
What is it?
Mines Rules.
Mines. Do you have mines rules? Do you dispute the text which they have?
No. Because I don't dispute, Milord. That is not readable. That's what I say.
Hallmark of Mr.
Because they have marked so much.
Milord, I am not disputed with regard to reasons. I am not, Milord, I am not that way that today I will dispute with that every point what they have raised.
The hallmark of Mr. Manti is fairness, man.
He said, I can't improve over
That's right, Lord. This is his hallmark. I know my learned senior.
No, whatever, Milord, the document, Milord, has to be read in a manner Your Lordship, kindly see 29Q, Workmen's Inspector.
Mr. Mohanty, just 1 second, we are interrupting you. Who is under your rules, who takes the decision?
Mines?
We want to know. Managing manager, general manager?
No. Your mines is headed by project officers. Project officers are of a different rank. If a small mine, then project officer may be a general manager. If it's a big mine,
So it all
then
depends
it's
upon- Okay.
chief general manager. So it's like, because we have 22 mines, according to my instruction, 22 mines. In 22 mines, what is the mines inspector? They will, for 3 things they will do. They will do, with regard to the installation, the electricity part, and they will the mines part. They will part this I will read, They will give, these are the 3 things that they will do, inspect with regard to. And the very first line is that they should be suitably, they shall designate suitably qualified employees. And you see the third line.
Who should designate?
The general, the project manager, the mine head.
Those 3 workmen employees have to be sponsored by whom?
Yes, by all union. Here, because there is no recognized union.
No, that rule does not say anything about recognition. at all.
There is no recognized union. There is no majority union. And once that goes, they have a concept that we are recognized, we are highest number, we should be. No. That is a wrong conception with them. It can be, a suggestion can become even having 100 members. Because suitably qualified. Then the suitable qualifications, the qualification itself is in para,
It's mentioned.
Yes, mentioned. At least 5 years. They said that in 2. No person shall be unless he possesses all this.
Mr. Mohanty, we had one more thing.
Yes.
We have heard you for quite long period, both of you. Somewhere it is lurking in our, doubt is lurking in our mind that there is no due consideration of the representation of the petitioner.
Lord, send back.
What do you say? Then within what period you will take a decision?
Your Lordship give a
Reasonable thing.
reasonable.
Appears to be very sensible. Because you took up the contention that so many points are not considered.
Very correct, well.
Secondly, we formed an opinion that there is no due consideration of the opinion
End
of
of the
the
matter,
advocate
end of-
general. It only quotes. In view of the above, we convey.
Right, well.
There is, where is the decision making? Therefore, as you rightly said,
From the very outset, I have said,
you have said that.
yes, Milord, if anything sort of.
Can we do like this?
Milord?
Can we do like this?
Yes.
We are giving the pattern now.
Yes.
The
The decision is your Lordship's. Consideration is of your Lordship's. Milord, we have to place it what the documents says. Nothing more.
Now, instead of we undertaking all that exercise,
Yes.
what we suggest is, we will make it our suggestion. So that both you have, after arguing, you have agreed with this suggestion.
Right.
That matter shall be remitted for consideration of.
Don't say that I agree. Because I am appearing for public sector, I am answerable
can't,
to many things.
But you may say, I agree.
I don't, your Lordship say that we remit back. Because that is your Lordship's command. Why not your Lordship use the command? No, your Lordship.
Court's command.
No, your Lordship use the command. I will see that would be implemented. It has to be. Your Lordship say that though we have gone through and opinion has been enclosed, yet we find that there is suitably considerations are not there.
Then we'll make the order.
Huh?
We make that order.
Milord.
That's fine.
Yes.
Kindly be seated.
Yes.
You want to say anything?
Yes.
Who are you?
I am
He is the
the
intervener.
Intervener.
You are the Restored Trade Union, also working under the MCA area.
No, we are remitting the matter. How you are concerned?
Well, my lord, what I tell you, some thing has not been brought to my lord's notice.
That's all right. But how? What is your locus?
My locus is that because of the direction of the this Hon'Ble court, reading and speaking order has been passed by the Coal India Limited.
Now, how you are concerned with this?
Because my lord, we are the members, we are also operating there.
No,
Because
you
they are going
operate.
there.
Who told you not to operate?
One thing, my lord, also can remember, I have filed all the documents.
No,
Only
you might
two
have
things,
filed
like
this.
there is also direction of the Apex Court.
No.
There is a direction of the Apex Court. I have annexed that.
Yeah.
That our Apex Court has categorically held that
Saying
unless and until that
you should be
original-
heard in the matter.
Yes, no matter.
Huh?
Your lordship.
No, who are you?
I am.
How are you enter the fray of the litigation?
Because I am the one of the writ petition in other writ petition.
You charge,
And also that has been addressed to all the areas.
you prosecute that writ petition. We are not coming in the way. We'll add one sentence saying that this order will not cast a shadow or light on that pending.
My lord, lordship.
No, we'll not.
No, one
You are not
commission,
to
ma'am.
understand, I said.
Because the
Otherwise,
entire-
we have great
that
respect
respect,
for
sir.
you. That's another thing. But who are you? Where is the locus?
My locus is my lord. I am the my lord the.
You don't have locus nor locum. Both.
Both, my lord.
No,
What happened, ma'am?
you better that go and have a cup of tea, I think. No, no locus in this matter. How you are agreed with it? You are miles away from the cause being exposed here.
Because our instance, our representation,
Huh.
my lord, lordship, I have annexed that representation at page 21 of my reply.
So that is being looked into by the other court.
Well, that will take into look into my.
Why we should say that?
How are you aggrieved by this?
This are how? Who are you? You are miles away from the order.
No, my lord. Your lordship has seen that one order. That is the order passed by the Coal India Limited
Yeah.
on 18. Lordship for 18 on 24/8/21
Yes.
in compliance of my lord's direction. Compliance.
You are another union.
Yeah, my lord.
Are they saying that you should not be permitted?
No.
No, they are not saying that.
They said he should not be permitted. He says it cannot be done that way. We are not in British era. We are in a welfare state. Ours is a welfare state. And the MCL is a state entity. Article 12 entity.
My lord.
Huh. No, you do not.
I have not, because but one direction from the Supreme Court has already.
Whether Supreme Court said you should be heard in this matter?
No, I am not there.
Then
Because
how-
there is a direction from specifically by the Apex Court. So, no matter for a moment, in our view, it will be for the parties to move the High Court of the original side of claiming whatever direction from the High Court in this way. This liberty is equally available to the petitioner. That is the.
And you have filed the writ petition.
No, that is pending matter written the original side before the Delhi High Court. The suit is pending.
Correct.
They are the.
How you can link
Because there are three groups: the ready group and the petitioner.
No, sir, you have not been excluded at all. You want to take path under the waters of other people.
May I request
You are concerned.
No matter, may I request, madam, may I have the liberty to file my objections in there in course of proceeding of the taken by the authority?
Well, not you, we will say all stakeholders will be heard in the matter.
Yes, madam.
All right?
You are right.
Right.
Now your lordship. Now your lordship will dictate or.
Yes, I will dictate the order. We will frugally mention about the contentions when we will give dictation. You are a registered trade union.
Yes.
A trade union registered under the provisions of erstwhile Indian Trade Unions Act 1926 is knocking at the doors of Brit Court for assailing the order dated, communication dated 29/1/2026, essentially assailing the communication dated 29/1/2026, a copy whereof avails at Annexure 1. First time. The said communication being short and sweet is reproduced below for ease of reference. Next. Learned senior advocate Mr. Ratho and Rautrai vehemently appearing for the advocate on record vehemently attack the impugned communication on the inter alia on the grounds that the same suffers from the vice of non-application of mind, semicolon.
the relevant material that was furnished by way of reply to the show cause notice have not been adverted to, semicolon. There is no application of mind by the decision maker who has structured the impugned communication being swayed away by the opinion of the Advocate General when law required himself taking the decision. Full stop. They have also cited a few decisions to highlight what is meant by consideration and also the requirement of furnishing the reasons even when the decision does not partake the characteristics of a quasi-judicial one. Also, those decisions are A, B, C, D. Next, learned senior advocate appearing for the counsel on record for MCL, per contra, vehemently resists the petition, controverting contentions advanced on behalf of the petitioner. First up, these submissions essentially related to absence of recognition of any trade union in the realm, semicolon, the idea of collective bargaining being given away under the new regime, semicolon, the impugned communication should be viewed not as a quasi-judicial order made by a trained mind in the armchair of law, but as a man trading law. Man in the trade of, man in the trade, semicolon. He also refutes the contention of the petitioner that all relevant factors have not been considered in the impugned order. Full stop. Next paragraph. Learned counsel appearing for intervener applicant seeks to say a few words on the subject matter of the list, and we decline to give audience to him in as much as the intervener is miles away from the cause we are treating at our hand. First stop. Next paragraph. Having heard learned counsel appearing for the parties and having perused the petition papers, we are broadly in agreement with the submission made on behalf of the petitioner trade union that the impugned order communication is not well structured, semicolon. Prima facie, it reflects a non-application of mind in as much as it only quotes what opinion the learned Advocate General in his letter dated 19/1/2026 had stated, semicolon. A serious matter as to the right of participation in the statutory and non-statutory meetings of the organization has not been has not been treated with due seriousness, and that would constitute an error apparent on the face of the record, warranting interference of this court. First stop. Next paragraph. On our own, we would have adjudicated the validity of the impugned order once for all, keeping in view the arguable right of the petitioner for participation in the statutory and non-statutory meetings, more particularly keeping in the light of rules 29Q and 29U of
Mines
Rules 1955, first off. However, we felt that the matter should be remitted, in the fitness of the things, matter should be remitted to the portals of the decision maker, portals of the MCL for taking a decision de novo, so that all contentions can be addressed by the decision maker after having wider consultation and after giving an opportunity of hearing to all the stakeholders in the matter, keeping open all contentions of the parties. First off, next paragraph. Ordered accordingly, and writ petition is allowed, semicolon. The writ of certiorari issues, quashing the impugned communication dated 29/1/2026 at Annexure 1, semicolon. Matter is remitted to the portals of MCL for taking the fresh decision within an outer limit of 8 weeks. 8 weeks, excluding the period of adjournments sought for by the stakeholders. First of all, contentions are kept open. In the facts and circumstances of the case, the courts are made easy. Okay.
My lord, all stakeholder, including the internal.
We do not. They will decide.
I am because I am.
Council will decide. We are grateful.
Next.
Item 20.
Thank you. We felt happy that the way the matter is conducted so effectively, and you are so fair. We only say this much. We can't say more than this.
This is Hallmark.
No, very fair. Yes.
My lord.
Ideal impact.
In item 20, my lord. My lord, the husband of the petitioner had taken a business loan from the opposite party number 1. My lord?
Serial number 20.
20, my lord.
Yes.
OP number 1, my lord. In the year 2023, my lord. And the sanction loan amount was, my lord, 35,50,000. And the present petitioner was...
1 second, start again now.
My lord, the
First one, first sentence. Who are you?
I am the petitioner. I am the wife of my deceased husband, my lord.
Widow.
Widow. My lord.
1 second. Husband had taken loan
35,50,000 in the year 2023.
25 lakh, 20,000.
35 lakh. 35,50,000.
50.
My lord.
50,000
in the year 2023, my lord. And the present petitioner.
Is it commercial loan or housing loan?
Housing loan, my lord. And the present petitioner was the guarantor, my lord. The wife was the guarantor. And the fixed EMI was, my lord, 48,475 per month. And my lord,
slowly.
How much?
48,475 installment, my lord.
Slowly. We are not that. You are going.
Yes,
model.
Yes, my lord.
35 lakh.
35,50,000. That was the
housing loan taken in 2023
yes.
by the husband of the petitioner.
Yes.
And petitioner being the widow happens to be the guarantor.
Yes, my lord.
And property is given.
Yes.
Security is given.
No, yes, property is given. Security is given.
That house itself is mortgaged.
Mortgaged. My lord.
Then what happened?
My lord, prior to this, my lord, the husband of the petitioner have regularly paid 22 installments, EMIs.
Totally how many installments?
My lord.
How many installments are in fixed?
No, my lord, I am just saying.
No, we want to know. Totally how many installments?
My lord, that is in the annexure.
We don't know. You have to tell that. We don't look into anything.
Yes.
We hear you. That's all.
My lord, because my submission is that my lord, installments is about 10 years, my lord.
It is for 10 years.
Yes, my lord.
Installment at the rate of 48,475 per month.
Per month.
For 10 years.
Yes. My lord, fact
180 EMI.
180 EMI is upon the Corona Regiment.
188 EMI.
180, my lord.
That you are not answering.
That is spread in 10 years.
And this is non-housing loan.
Not housing loan.
Not housing.
But he said,
I'm coming to my lord, my lord.
not committing. You said housing.
My lord, the husband of the petitioner have regularly paid 22 EMIs from the date 3/2/23 to 3/11/24 without any default.
Mr. Counsel,
Yes, my
you
lord.
must be very fair.
Yes, my
Very
lord.
What is your application?
We are not your opponents.
You start with your application that the petitioner have taken a business loan. And you say,
And
that
you
it
say
is-
housing loan. Why can't you read what you have written?
I bow down, my lord.
All right.
Well, my lord, fact is that, my lord,
Out of 188, how many installments you have paid?
I have already paid 22 installments regularly. Thereafter, my lord,
One
Wait,
second.
wait.
Why you are in so much hurry? 22 installments. Last 22nd installment is paid on which date?
3/11/24.
Remaining installments were not paid. Why?
Because, my lord, the loan was insured, and for that I have paid the account from my account. They have deducted 65,893 rupees to ICICI Prudential Insurance.
Who appears for ICICI? Yes.
Yes, sir. And the loan was totally secure then, my lord.
When the loanee died?
Loanee died on, my lord. Loanee died on 11/7.
8/11/2020.
8/11/2024.
So last installment was paid on 3rd of 11 and he died on 8.
No, my lord. Again, they have given me a 13 notice. Thereafter, they have sent
You are
me.
going in a different way. We are in
Here, even according to you, what all we have written, we are telling that. You are in hurry. You are not in.
No, yes, my
You are
lord.
not in good mood today.
No, my
You
lord.
are you in good mood today?
My father is passed away today.
You want time?
No. I just want to complete
You want
it.
order?
I just want to complete it, and fact is that, my lord, after the 22 installments, they have given me 13 notice. Then that 13 notice.
Dated.
Yes, my lord. We have legal notice 6/25, my lord. That is legal notice. And 13 notice was issued to me on 12/3/25.
on 12/3/2025.
Yes, my lord. That 19 and 23.
Dated.
12/3/2025.
And my lord, here I am to say, one legal notice they have sent me on 6/25. After that legal notice, I have paid another one installment.
That becomes 23rd.
23rd.
Legal notice was sent on
6/25. My contention is that here, my lord,
After the 23rd installment,
Yes.
they issued 13/2.
Yes, my lord. And fact is that whenever I had been to them bank, they have told me that without any reason, insurance company has denied us, repudiated us, denied us.
It's a complete secured, no?
Complete secure.
You have remitted the money.
One minute, that is there.
We'll ask them now. Anything more to be said?
No, sir. This is
Okay. Yes, brother. You have taken money and you have repudiated the claim.
My lord, in fact, it appears that they have wrongly inflated ICICI Prudential. In fact, the insurance is perhaps, as it appears, it is perhaps with Bajaj Alliance.
And
Yeah.
for- it is bank statement here, my lord, that is Annex 1. I have.
Brother, Mr. Brother Bank, with whom it is insured? It is a tripartite arrangement. You are the, in fact, you are the vicarious beneficiary.
ICICI Prudential, they have mentioned it here.
This is Jana Small Finance Bank.
Yes.
Then you
It's a bank.
misled them and therefore it has happened.
Yes. But in fact, my lord,
You implead, sir, you implead that company instead of wasting time.
but I don't know, my lord, because in that.
No, now they are saying,
They will say.
Now they are
Krishna, the
saying-
account statement. Your account statement here, ICICI Prudential Insurance, ICICI Prudential Insurance, 33,457, 32,437.
They must have
wrongly. You implead, we'll leave that person now. Because he has nothing to do with
Annexure
you.
1,
Yes, my lord.
that speaks of Jana Small Finance Bank.
Yes.
Branch code is there.
It's a bank who finance, my lord.
Huh?
I am applying for the bank.
Oh, that is your bank.
Bank finance, but my loan was
But,
issued.
with whom you insured?
That we should know.
That money, that premium is remitted by the bank to whom?
Let it come next week as well. My lord, it is mentioned here. That is ICICI Prudential.
It has to be done. How you say that you are not the bank? You are not the insurance.
My lord will file an affidavit to that effect. However, in fact, they have not also disclosed the policy number and the order of reputation they have not annexed in this. So it is not very clear in us as well. But prima facie, this is what we have been able to ascertain.
The bank, the OP number, what is that OP number?
OP number 1 is, my lord, Jana Seva,
Exit bank.
branch manager, Jana Small Finance Bank Limited at Samantarapur, Chandrasekhar Nagar, plot number 19.
OP number 1 is hereby directed to furnish full address and full particulars of the insurer to the petitioner.
Yes, my lord.
Petitioner, along with the policy details within 1 week, failing which OP1 may be saddled with a cost of rupees 10,000 payable to the petitioner. Yes. Call this matter next week. Yes.
My lord, not next week, after 11 days, my lord.
All right. After 2 weeks. Yes, 2. You furnish those details first. In the meanwhile, it is open to the OP insurer to file its counter, if any. Failing which, right to file one stands forfeited and petition averments may be taken with face value.
Obliged. Kindly pardon me. Kindly pardon me.
Yes, sir. Yes.
In that case,
They have come now.
I have ready the compromise petition. I'm sorry to say that.
Yes.
My client is not willing to sign.
Not ready? He wants it to be decided according to law. Okay.
I am agree with my lord.
Correct, but if his client is not agreeable, what he should do? We can't compel anybody here. In this matter, we held chamber proceedings.
No, not it.
Not necessary. Chamber proceedings. I try to work out an amicable settlement. First now. Therefore, post this case before other bench for consideration. Okay. Man.
Item 21.
After taking necessary orders from Honorable the Chief Justice. Okay.
Item 21. WBC 6066 of 2026.
I'm for the.
Put this note in an earlier case.
I'm for the.
Who is your friend, brother? Your friend is not here. He has taken any interim order?
Next part is
We'll have it next week.
filing my with a prayer to accept the Vakaltu Nama.
Learned panel counsel Sri so appears for OP number 3. Others are served now.
Others will state, my lord.
Others are state district
1 and 2, my lord.
1 and 2 by ASC, Mr. Rick. Yes. Call me doctor.
Item 22, WBC 7244 of 2026.
Here I am appearing for opposite party number 1, madam.
OP number 2 and 3. 3 times appears for OP1. Madam appears for OP 2 and 3. Yes. You want to file objections?
If the prayer for OTS.
Prayer for OTS. You consider that.
My lord, my OTS application is accepted and I have paid the amount. Now the only 45,000 is there. And they have assigned to the ARCIL. And ARCIL sent notice 7 lakh something.
Lord,
Whether OTS is
OTS was
accepted.
accepted, but
In
the
time, how much was? What was the OTS amount?
OTS amount
90,000, my lord.
So borrowed amount is how much?
7 lakhs.
7 lakh 50.
The OTS is
6. Out of that, I have paid, your lordship may see,
how much you have paid?
I have paid.
This loan
I
was
have
taken
applied in
when?
my
Which year?
petition, my lord. Your lordship may see, page 5. 2019 to 2020, I have paid 1,33,886. And 2021, I have paid 94,815. 2022, I have paid 89,538. And 2023, I have paid 1,71,732. And at 2024, I have paid 1,71,732. My lord, but they have accepted and I have paid.
Where is the OTS acceptance?
Your lordship may see.
So you have paid in total 8,64,659.
My lord. And now he is claiming they have, your lordship may see annexure 4. They have stated there is no payment, installment overdue is 0 and total due is 0. Now they have assigned to ARCIL and ARCIL again further.
If every amount is paid, how could you assign it to others?
Paid within the tenure, it is admitted case. It is not paid within the tenure.
How much delay?
My lord, in fact, the entire amount of the OTS amount is still not paid.
How much?
That is 45 lakh as per his admission.
45 lakh or
45,000.
45,000. You accept that 45,000 plus 18% interest and put an end to this. Otherwise, we may impose cost on him.
Let's let him approach, my lord. We'll consider with a lenient.
No, yeah. See, OTS of 6.70, only 45 is remaining. Totally 8 lakh odd is paid.
Let's make direct with interest from 2023, from the last date of the OTS payment.
OTS amount. That on 45 you pay that. Okay? The borrower is knocking at the doors of the court for laying a challenge to the entrustment of the loan in question for recovery to OP numbers 2 and 3. To whom it is? To whom it is entrusted?
1.
Assignment has happened with whom?
It is happened with 1, my lord, by 2 and 3.
2 and 3 are the lenders.
Are the original.
Recall that. The borrower is knocking at the doors of the court, essentially for assailing assignment of the loan in question by OP number 1 lender to OP number 23 lenders to OP number 1
ARC.
Huh?
I am the ARC, Assist Reconstruction Company.
ARC. Asset Reconstruction Company. First, learned counsel for the petitioner, taking us through the pages of the petition. Her client's OTS came to be accepted for a sum of rupees 6.70 lakh as against the borrowed sum of rupees 7 lakh.
Should I make a submission in correction? In fact, he has supplied that he has taken 2 loans, another is 50 lakh loan.
No.
Yes, it is there.
Yes, that is COVID loan, my lord. I have sent a notice.
No, that
but
is
they have-
whatever you want to do that.
Fine.
So far as this is concerned, we'll put 10.
Fine.
This one. 7. Full stop. She also tells that even in respect of the original loan, totally a sum of rupees 8 lakh 64,659 has already been remitted by way of repayment in terms of EMI. As per the EMI. Full stop. She very fairly admits that there is a shortfall of rupees 45,000. 45,000. And her client is ready and willing to remit the same with the interest at the rate of 12%.
My lord.
Yes. But otherwise it fails. Now,
My lord, I will say, my
the
lord,
judgment of the apex court.
my lord, I will say one thing, my lord. I have paid one amount, 2 lakhs, in the, your lordship may see. I have paid 1 lakh, 2 lakhs, and they have credited after 1 year. That is why I am come before your lordship. On 16 to 23, I have paid 2 lakhs, but they have credited on 23, 124, my lord. I am a poor man, my lord.
It is done by RTGS.
My lord.
What do you say?
Well, here and but to some extent she is correct. That amount he deposited in the company account, not in the loan account.
But all right.
But it was subsequently it takes some time to take it from the company.
Almost 1 year.
1 year, my lord.
That has been some.
There is no interest in payment. You accept that 45,000.
My lord, may Lord Simeda allow me, I can clarify what is the under what circumstance that was the delay was caused. If that is
no, whatever may be the circumstance. What is the fault with the borrower?
But even if for that 1 lakh, my lord, rest amount admittedly she has paid the last amount on 19/1/2026.
How much it will be?
But total amount as per her admission, it was 6,69,896. Page 13 is the return.
That is 6.70.
My lord, 6.70 she has money paid.
Correct.
My lord, the balance amount he has to pay with the interest, my lord.
Why interest? But you have written for 1 year, you have written 2 lakh rupees.
My lord, even if that, my lord, leaving about 2 lakh, my lord, but balance amount, OTS cannot be extended, lordship. No, this is the.
That's all right, but there are.
I am not going to that, my lord. Just for the equity, my lord, let him pay. Even not 12%, 10%, let him pay, my lord.
Now 7% he will pay. 7%.
Too less, my lord. It is not even the
7%.
FD account. Let it be 8%.
7%.
7% because the share
Your
also
lordship,
suffers.
please.
What you have written? 45,000.
45,000.
You want
801.
8,801.
Actually. Ready and willing to remit the same with interest at the rate of 7%. 7%. First of all, this is a very fair submission, especially regard being had to a sum of rupees 2 lakh being remitted by RTGS to the OP1.
It was actually remitted to 2 and
OP numbers 2 and 3, which was not taken account of almost for a period of 1 year. 1 year. First of all. Next paragraph. Learned counsel advocates appearing for OPs resist the petition, contending that in matters of OTS adjustment, ordinarily the rate court should not grant indulgence. First, they also submit that if there is any grievance, petitioner can work out the same by making an appropriate representation to OP numbers 2 and 3 in consultation with keeping OP number 1 also in the loop. First, next paragraph. Having heard learned counsel for the parties and having perused the petition papers, we are of the considered view that justice of the case warrants our limited interference. First, the interference, in as much as the petitioner is demonstrably a fair and scrupulous borrower. First off, a shortfall of rupees 49,000. 45,801 should be permitted to be remitted in terms of OTS. Of course, with the interest at the rate of 7%, accruing due thereon with effect from the date the same was payable until it is paid. First, next, in the above circumstances, this petition is disposed of, permitting the petitioner to pay, make good the shortfall within 3 weeks. Within 3 weeks.
ଗରିବ ଲୋକଟା 7,000 ରେ ଚାକିରି କରିଛି ବାପା
Yes, about 2 months, my lord.
2 months.
Within one.
Clear cut.
No, within
1 month.
Within 1 month. First, if the payment is accordingly made, the OP numbers 1 and 2 shall remit OP1 will accept the same now. OP1 being the assign of OP numbers 2 and 3 shall accept the same by way of full and final settlement of all dues. First, however, in respect of any other loan, the legal process shall follow. And in that connection, we have not said anything. Okay.
Lordship may observe a default clause in the does not pay within that period, Lordship.
In the event the payment is not made within the period prescribed above, the petition shall be treated as having been dismissed. Dismissed. And coercive actions follow. Next.
Item 23, 24 have been adjourned. Item 25, Head Appeal 1088 of 2025.
Lordship, the order of the Honorable Single Judge, my lord.
Yeah.
I challenge only one part, my lord. Lordship, page 38, my lord. Page 38 of the appeal.
It takes some time. We are also tired. It takes some time. It's not within 5 minutes. We cannot finish it.
I think it will finish. Only one point only.
Yes.
I think only one point, my lord.
Yes.
Your Lordship, page 38, paragraph 22.
8.
Page 38, my lord. Page 38, my lord.
Paragraph 22.
Paragraph 22.
Recruitment cycle.
Since the recruitment cycle has since concluded and notified vacancies having filled, the opposite parties are directed to consider the petition of appointment against the post of equivalent nature and status within the same cadre and pay scale originally applied for subject to his being declared medical fit. My challenge is that only, my lord. I have been declared as medical fit, my lord. Your Lordship, say page 22, my lord.
So your grievance is only against that qualification?
Yes, my lord. Pursuant to a direction of this honorable court, my lord, the medical board of AIMS, my lord, had declared me fit.
Where is that?
Page 22, my lord.
Annexure 8?
Annexure 8. The direction of the court is that
without any hindrance from his decease. Yes, brother, who appears for the OP?
DSG.
DSG. Oh, DSG will.
I'm sorry, my lord. I'm in virtual mode. Virtually.
Yes,
I
sir,
thought
Mr.
that you
Patti.
will not reach this.
Yes. Mr. Padi, there is already a medical certificate which says he is fit.
But Lordship will submit the documents which contrary because there is no evidence in respect to the particular disease what I mentioned.
No, there is a medical certificate.
You
want medical certificate?
That was disputed, my lord, because the medical certificate issued by the board is
Yes.
contradicted by the petitioner, again refer to the AIMS. And the All India Medical Science has given a certificate where this particular disease are not taken into consideration. This is the instruction of the department.
Para 22, to the extent it says that subject to he is being found medically fit goes. How many times man should go to the medical board and get certificates?
Yes, we have
only once.
Once
Yeah,
I
but-
recruited PSC Medical College. Once
the recruitment process, there is
Medical
for the all
Then I
the
went
selection,
to AIMS.
there is a medical board.
No, Mr.
For
Nara.
selection of all the candidates,
There are
using the
purposes of
CRPF,
the-
CSF, SSS, everybody. There is a one medical board. There is a legal constituted by the particular body. And here, because he had disputed matter is referred to, and it is also coming in disputed fact. That's why no evidence is about a particular disease.
No, no. Subjecting a person to medical test again and again is inhuman. It is inhuman.
Basically, medical board is declared unfit.
We may impose cost. Why this?
May I pray, my lord? Some other day I will come physically.
No, brother, no, brother. In all other matters, we have given you accommodation. Not in
Yes,
matters.
But my lord, it is a case, Honorable Single Judge passed an order describing the factual facts. And all things has been elaborately discussed. Thereafter such order has been passed.
Yeah, that is wrong.
Yes,
Therefore, he is before this court.
definitely.
Last year,
The appellate court definitely, the single judge.
you can't subject a citizen to the medical test often. That is not a happy thing to happen. Who will go to the medical test happily?
That's super. But because it is not properly, evidence is come out, that's why.
By the aspiring recruitee seeks to call in question a learned single judge's order dated 9/5/2025, whereby his WP 26844 of 2020 has been partially favored, conditionally favored in the following words. There are 23. 22 and 23. Reproduce. Next paragraph. Learned, after service of notice, learned, the OPs having entered appearance through the learned TSD opposed the writ petition, making submission in justification of the stipulation of the condition of medical test. Yes, first. He also submits that it is a well-considered order, and therefore the writ court should not readily grant indulgence in the matter. Next, having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter only on the ground that the petitioner has already been adjudged medically fit. Which is that?
Page 22, Annex 8.
Medical wide minutes of meeting of the medical board, AIMS Bhubaneswar, dated 22/4/2024, a copy whereof avails at Annex 8. First off. Next paragraph. For ease of reference, the said minutes of meeting is reproduced below. Next paragraph. When already the petitioner, having undergone medical test, has been found to be medically fit for the job in question, there is absolutely no reason or logic in asking him to undergo one more test. First of all, after all, subjecting a citizen to the multiple medical tests is highly undesirable, to say the least. subject to all just exceptions, into which argued case of the OP's respondents does not fit. Next paragraph. In the above circumstances, the impugned order to the extent of prescribing a fresh medical test is modified to the effect that there shall be no need for again petitioner undergoing any medical test. First, in all other aspects, the impugned order stands and shall be given effect to by the respondents within an outer limit of 8 weeks. 8 weeks. And failing which, and is not necessary, failing which, the respondents run the risk of severe contempt proceedings.
Appearance will not be. My lord, my appearance may will no.
He is appearing with
Along with learned is.
And where have you assisted the court? You have not assisted the court at all. Party has argued the matter. Party assisted by so and so, so and so.
My lord, item 25 of second list.